second item, which has been filed by the husband, the divorce. That there stays there, and in the first item, lordship is granted stay. What I am submitting, my lord, if your lordship has not signed the order or dictated the order, can I take instruction in the matter?
Upload judgment result. I think both matters were tagged.
Sir, second the husband first issue because ladies are involved.
Okay.
Your lordship said that ठीक अच्छी मुझे मत पचारे मु संध्यारे कथा होतले द ट्रायल कोर्ट लॉयर से कहला टिके कथा हे जिबा जदी बेटर हो सी भी लेक्चर दागा पिक्चर रे कटक की भुवनेश्वर
हां अपलोड जदी हे नथो ताले ताको आउरे डेट कर दो
सेकंड सर सुनानी है
नहीं ठीक है फर्स्ट आर्गुमेंट I will instead of keeping it for reserved for judgment I'll adjourn it to another date
सेतरे स्टे था किंतु फर्स्ट
stay
सेकंड स्टे अछि
all right
beg your pardon, my lord, sir, on transfer matter.
Pardon to make a mention, my lords. There's an RSN number 248 of 2024, my lords. Here the respondents have proceeded with the execution case. My lords, it is not listed today. This is RSN number 248 of 2024.
Just a moment.
Yes, my lords.
Number 22 of the supplementary list.
My lords, it has not
mentioning for supplementary list.
Yes, my lords. Yes. The next date of execution is on 13.
Just a moment, sir. I am hearing another mention. Please wait. Item 22. Yes, what do you want?
The matter may be taken on any other day, Lord.
List this matter on 25th September. Yes. Yes.
Yes, my lords. The RSN number 248 of 2024, my lords.
Yes.
The respondent have already proceeded with the execution, my lords.
File a memo. File a memo.
My lords, I have already filed, my lords.
When did you file?
My lords, it has been filed on 28th, my lords.
You file it today? No. File it today.
My lords, I'll file it.
Yes. File kare to list kar do. Dakho.
List item number 1, next admission.
May I please, Your petitioner before your lordship has become a scapegoat in a very unfortunate spat which has arisen between the trial court and his lawyer, erstwhile the previous lawyer. And kindly see, I'll just take your lordship to one order, which is at page 41 of TRP 74 of 24.
Yes.
Page 41.
Yes.
Order dated 5/4/24. The order arises out of suo motu judicial notice. The present circumstance of the case record is that on 18/3/24, the examination in chief was completed from the side of the complainant, in which exhibits were marked. On the same day, cross-examination was heard, but the learned counsel for the defendant submitted that the complainant had not supplied them copy of the affidavit evidence as per rule, for which he did not receive the same and prayed for further cross-examine the complaint on the next day after proper service of affidavit evidence. The prayer was allowed, and the next day the cross-examination was continued after compliance of the copy service. Thereafter, your lordship may skip 1 or 2 lines and then a sentence beginning in the presence of the learned counsel for the complainant.
Yes.
The complainant, other learned advocates had already marked exhibits, that is, check and other documents were given to the learned counsel for the accused for perusal before the court in open dais, and the complainant was cross-examined on the basis of it. The learned counsel for defense cross-examined the complainant at length, and the evidence of the complaint was thus recorded. On 21/3/24, kindly mark the date, on prayer of the learned counsel for defense, the record was intimated about the situation, requested to cooperate with the court and check through his files to find out whether he had mistakenly kept the original documents pertaining to this case in the file. He did not reply to the said query and orally said he will look into his file. Today, the learned defense counsel was present. He was asked to cooperate with the court regarding this case, but he denied to have any knowledge regarding the memo or the relevant documents. Therefore, this court suspects that the learned counsel for the defense has knowledge regarding the same, but he is giving false statements as regards to its whereabouts. Hence, intimate this matter to the Honorable District Judge, District and Sessions Judge Jajpur as the provisions of Rule so and so is there. Thereafter,
So what happened? But
now the entire this was the version of the court.
but what actually I couldn't understand what was happening.
I tell you, the entire thing. Kindly see Annexure 7 at page 30.
Yes.
This is a letter addressed by that lawyer, previous lawyer, to the Registrar General of this Honorable Court. Kindly take the last two lines of that page. On that date, I had extensively cross-examined the witness for about an hour and a half. I had also confronted the witness with the exhibited documents, and during that course, I had taken aid of the said exhibits with the permission of the court. After examination, I had returned the exhibited documents, including Exhibit X, and the witness was discharged. The complainant thereafter preferred to close his evidence, and the court agreed to record his statement of the accused on the very day, in the last part of the court time. I applied for certified copies of the depositions and exhibits. I had also applied for certified copy of the FIR in Jajpur PS case number so and so and corresponding city case pending before the same court. The court recorded the statement of the accused at 4 p.m. to 4:30 p.m. from the chamber while the accused was answering from outside through the window. The accused signed the recording in the courtroom. Thereafter, I returned next para. I had again been to the court of the JMC Jajpur on 29/3 in so and so, where my client, namely so and so, is an accused, where advocate for the complainant is the same in 1cc case number so and so. And on that date, the advocate for the complainant took time, whereas the case was posted for examination of recall of the case. Recall witness in the same. Next para. On 2/4/24, the incident is of 19/3, then 2/4/24 at about 8:04 p.m. PM. I received a call from Mr. Jagannath Pati, advocate for the complainant in both 1cc number so and so, and intimated me that the court master of JMFC court is trying to contact me, and immediately thereafter the court master called from mobile number so and requested if the exhibits in case number so and so might have been wrongly kept in my file. Though I was sure that the documents were not with me, as the same were returned diligently to the concerned peskar of the said court, otherwise he would not have let me out throughout the court. Despite that, as per his request, I verified my file and did not find the documents. I called back and informed him that I did not have the documents, and he informed me that there was CCTV footage that I had kept the documents in my file. So I took it more seriously and again verified and did not find the documents. So we concluded the call on that note. Thereafter, next para. When we arrived on 5/4/24 at Jajpur so and so, I had previously prepared a written petition with a prayer to summon the banker of the complainant for the purpose of confronting material discrepancy in the case check, as the complainant had closed evidence from his side. I submitted the petition in court attaching a copy of the complainant, as neither the complainant nor his advocate were present. The peskar, seeing us, did not say anything about the issue of loss of documents, so I confirmed to the court master that the calls were made by him, and he blamed me that the CCTV footage showed that I had put the documents in my file. The PO came to the dais soon after I had made a mention with regard to the petition I had filed on that date, when suddenly the PO said, "Apunuku mu okilo boli babu nahi." I was shocked, and then pointing to the CCTV cameras, she said, "Jaha nahi thile ferei diontu, sabu footage achi." And then she said, "Profession career nosto heijibo." I was dumbfounded by such allegations when Mr. Patnaik stood up and humbly expressed that since court had questioned the professional ethics and credibility of the advocate, judicial inquiry is the best option to go for it. He also asked me whether I was ready for judicial inquiry, to which I said I did not have the documents. I am ready for judicial inquiry. Now, this is the background. It is for this background. Now, what happens is my lawyer has abandoned me. He has gone. He said that I will not conduct the case. I have engaged.
This is the same person who was written to the RG.
Yes,
Yes.
he has left the case. He has said that I will not handle because allegations are being made against me. I will not go to that court. He has engaged another lawyer. Now, without giving him an opportunity of being heard, the court is proceeding with the matter. Even though the petitioner has been on an application under 205 CRPC was allowed, a warrant was issued, I was arrested, I had to apply for bail, and I have been enlarged for bail. Thereafter, my lords, I am not allowed, my petitions are being rejected, certified copies thereof are not being granted to me, and now the court, without hearing arguments of my lawyer, has posted it for judgment.
All right.
This is the situation.
All right. You should notice the opposite part. Join opposite party.
Uh-huh.
So the opposite party by speed post fixing a short returnable date, requisites be filed within 3 working days. List this matter
30th October.
on 30th October. IA it is submitted that hearing of the case has concluded and the matter is posted for pronouncement of judgment. You know the date?
5th
Judgment on 5th September.
5th September.
Having regard to the averments made in the transfer application, this court directs that the judgment shall not be pronounced by the trial court until further orders. Yes.
Both the cases same, because the same
Both the cases,
petitioner in both the cases, 1 and 2.
Okay. All right.
Same
Two.
court.
Same.
court.
Item number 3.
So what happened to that document actually?
Again,
What happened to that document?
one.
Why are they saying that your lawyer, earlier lawyer had taken it?
Because he was the last person seen holding it while he was cross-examining. Thereafter, cross-examination was closed. Accused statement was recorded on the same day, later in the day. And thereafter, 12 days thereafter. 12 days thereafter, a call is made that the documents are missing.
No, you wanted to be transferred from which court to which court? From to which court?
Any other court. Any other court. Let it be to SDGM, the nearest SDGM. Let it be brought to Cuttack, any place. That court, for these reasons, it's already formed an opinion against me. In fact, I can show orders. There are orders passed which shows that he already has a preconceived.
Okay. So, but there has to be an inquiry relating to loss of the court document.
The district judge has ordered that some inquiry has already taken place. In fact, as far as I know, even the Registrar General of this court was moved. But beyond that, I have absolutely no
No,
knowledge.
this must have been taken note of. This on the administrative side of obviously.
Yes, must have.
Something must have been done.
Must
So,
have been. They're very serious things. And even assuming that the documents were removed by someone, how is it that it comes to the notice of the court after 12 days? When on the same day, the court has done the accused statement. Without the exhibited document.
let us see. Let the other side appear. We'll see. Yes.
Okay.
Item number 3.
The petitioner, the wife Miller, has filed this case against the husband with a prayer to transfer the suit filed by the husband before the London Judge Family Court Cuttack to the Judge Family Court Puri.
All right. Notice stay. Date go.
30th October.
Hmm?
It is October.
30th October.
I want to pray for a stay of the.
I've already granted stay.
Item number 4.
This petitioner is the wife. Preferred this transfer case for transfer of this CP case 120 of 2024 from the family court Raulkela to family court Kandama at Pulwani Miller.
All right. Notice stay 30th October.
5.
Sahan for the wife Millers. The
Yes.
husband and the wife both belongs to Puri Millers. I filed a 125 petition before this. Just to harass him, the husband filed the petition deliberately knowing that she cannot come because blessed with small kid and staying with the others and they are all Ulias.
All right. Notice stay 30th October.
Item number 6.
Wife and lordships. This is initiated against the wife and suit your lordships. And London Senior Division Riding to your lordships. Should the learned civil judge senior division Korangi your lordships.
Raipur to Karanjia, how far it is? Not 80 kilometers. No, Raipur to Karanjia, 80 kilometers. All right, notice, stay, 30th October.
Now 7.
Next 9, the petitioner was disengaged from Ramanujar Sevak minor on the alleged that unauthorized absent minor.
Annexure 9. Annexure 9.
Page 31.
Hmm.
And due to proven illness violation, the petitioner has gone to medical and has submitted leave application to the surplus. My lord, under annexure 10, my lord, he has approved the RDC against the disengagement.
No, RDC is not the authority. I think Director of Special Projects. Yes, Mr. Das. I think Director of Special Projects is the appellate authority
Yes.
as per the comprehensive guidelines.
GRS the same.
Gram Roजगार Sevak.
Yes.
Did he file an appeal before the Director of Special Projects seeking condonation of delay? The petitioner was working as Gram Roजगार Sevak in Gonda Bahali GP. Stop. He was disengaged by order dated 9/9/2020 passed by the collector, Nuapada. It is his case that because of his ailment during the COVID-19 pandemic, he was unable to discharge duties. Accordingly, he has preferred an appeal before the RDC Southern Division, Barampur. This court, however, finds that as per the comprehensive guidelines issued by the government, appeal against the order of disengagement lies to the Director of Special Projects. Stop. The writ application is therefore disposed of, granting liberty to the petitioner to prefer appeal before the Director of Special Projects within 2 weeks from today, along with petition for condonation of delay. Stop. If such appeal, along with petition for condonation of delay is filed within the stipulated period, the same shall be considered in accordance with law by the appellate authority after granting opportunity of hearing to the petitioner. Yes.
All right.
Item number 8.
That's all.
Item number 9.
May. I have challenged the notification in relating to Jalda 1 Anganwadi. Annexure 1, page 12.
कौन है चित्र?
My lord, there is a minimum qualification of 10 plus 2 men for the candidate to fill up the post of Anganwadi. And your lordship candidate page 13, paragraph 7. ପ୍ରାର୍ଥିନୀ ଯଦି ଦ୍ୱାଦଶ ପାସ୍ କରି ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର ସହାୟକ ଭାବେ କିମ୍ବା ଉପକେନ୍ଦ୍ରର ସଠିକ ଭାବେ 5 ବର୍ଷରୁ ଉର୍ଦ୍ଧ୍ୱ କାଳ ସମ୍ପାଦନ ରୂପେ କାର୍ଯ୍ୟ କରିଥାଏ ତେବେ ପ୍ରାର୍ଥିନୀ ଯେକୌଣସି ବର୍ଗର ହୋଇଥିଲେ ମଧ୍ୟ ଅଙ୍ଗନବାଡି ପଦବୀକୁ ମନୋନୀତ କରାଯିବ. The petitioner is working as an Anganwadi helper in that center. He has also passed matriculation. In the old guidelines, my lord, where he has appointed at that time, 2007. The minimum qualification is metric. And in the meantime, my lord, that new guidelines come into force and it was enhanced to plus 2 men. But there is a clarification from the government, my lord. Annexure 6 series, my lord, I have given. The additional secretary to government, my lord, has clarified that those person who was earlier appointed under the old guidelines, they are eligible for the post and matriculate. But in the notification that there is no such exemption in the notification. It is that plus 2 is there For that reason, my lord, I may be I have applied for the post. Till that completion, my lord, selection
Well-
process is going on, my lord.
Yes.
Let notice go.
Well- You will accept notice, so
Yes.
learned AG accepts notice on behalf of all the opposite parties. Let a counter affidavit be filed within 4 weeks. Does this matter? On 30th October. As an interim measure, it is directed that the selection process pursuant to the notification dated 6/8/2024 may continue, but the same shall not be finalized till the next date.
Item number 10, pattern matters.
That's all.
Item number 11,
That's all.
item number 12,
Item 12, and please, Your Lordship. Here I am the petition 15. Oh, I'm sorry.
Yes, item 12. 13.
item number 13,
May I please, Your Lordship? My lord, this is an old matter, but my interim order is there, my lord. My lord, I have no instruction, Lordship. Let this matter come up 1 week after, my lord. I will obtain instruction because the petition is continuing by virtue of interim order, my lord.
All right. As requested by learned counsel for the petitioner, place this matter on 11th September.
My
Interim
lord,
order to
I need
continue.
taken over 2 weeks after, my lord. My lord, old matter, my lord.
11 September ले हूँ out to पड़ता पर कर दे 18 September.
Grateful, my lord.
Yes.
item number 14,
चलो. Yes,
item
sir.
15,
My lord, in item 15, there are two petitions. In one, I am the petitioner, the other, my friend is the petitioner. This may be subject to Your Lordship's kind consideration, may be taken up after 10 days. This came up, I'll just take instruction. Your Lordship may kindly fix a date after 10 days. my lord.
Yes, Mr. Das, what do you say?
Yes, well.
Petitioner. No, he wants time.
That
What's
one I
time?
know, because I'm continuing since 2010, man.
No, that will not be equity, that I will assist, my lord. I couldn't take instruction because it came up suddenly. my
All
lord.
right. As requested by learned counsel for the petitioner, let this matter on 18 September.
Grateful, my lord.
Interim order to continue.
Interim order to continue. The learned counsel for the parties are requested to come ready for final hearing.
Grateful, my lord.
item number 16,
Hearing. Grateful.
Yes, Mr. Mishra, what is this?
in 1998, there is an advertisement for the post of Hon'Ble worker. And the petitioner and others, they have applied for the same. And in the selection, the petitioner was selected as Hon'Ble for Saharadia Hon'Ble Center, and she was joined on 1/6/98. While he was continuing in 18/3/2016, after 18 years, some of the, due to the political dispute, some of the villagers made allegation against the petitioner, by virtue of which Annexure 1, page 16,
Yes.
was issued by the CDPO on 18/3/2016 against the worker and helper, alleging that they have not supplied the aid, they have not kept all the assets in the Anganwadi center, and the mother of the petitioner, he has abused to the villagers, and the petitioner has misbehaved to the villagers, and some other allegations. Till today, from 98 till today, there is no Anganwadi center. The authority has only given one table, one chair, and one trunk.
No, what happened? Did you reply to this?
Not because only 3 things they have been supplied: one table, one chair, one trunk. The petitioner is the Anganwadi, he has kept all the things in the trunk. And the school was running in the Saharadia UP schools in the Baranda. From morning to 10, the students have come, and after completion, again he has stacked all the materials in the trunk and taken to his house, because there is no Anganwadi center. While is continuing after 18 years, this is the allegation. Against that order, the petitioner filed an writ application before this Honorable Court in 5/5 of 2016. After hearing, this Honorable Court directed to file an appeal before the collector.
Appeal before the collector.
Yes.
But here only a show cause notice was issued against you.
Yes, so cause.
लिखा है तुमको निर्देश दिया होइछि कि
So cause नहीं.
प्रत्येक 3 दिन मध्यरे तुमको हमको आसबाबपत्र तथा कागजपत्र और चावल सह दायित्व को उपस्थित अन्यथा आईन to hand over charge.
I have handed over charge.
So there is no order of disengagement as such.
ଏଥିରେ ଅଛି ଯେ ସୁତରାଂ ତୁମମାନଙ୍କୁ ନିର୍ଦ୍ଦେଶ ଯାଉଛି କି ଉକ୍ତ ପତ୍ର ପ୍ରାୟ 3 ଦିନ ମଧ୍ୟରେ ସାରଡିଆ ଏକ କେନ୍ଦ୍ର ସମସ୍ତ ଆଶା ପତ୍ର ତଥା କାଗଜ ପତ୍ର ଚାଉଳର ଏହି ଦାୟିତ୍ୱ ସାରଡିଆକୁ ସାହାଯ୍ୟକାରିଣୀ ଶ୍ରୀମତୀ ମିନତି ପରିଦର୍ଶକଙ୍କୁ ଉପସ୍ଥିତ ହସ୍ତାନ୍ତର କରିବ ଅନ୍ୟଥା ଆଇନ ଅନୁଯାୟୀ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରିବ ଏହା ସହିତ ସାରଡିଆ ଏକର କେନ୍ଦ୍ରକୁ ଅନିର୍ଦ୍ଦିଷ୍ଟ କାଳ ପର୍ଯ୍ୟନ୍ତ ବନ୍ଦ କରାଗଲା ଏବଂ ତୁମର ମାସିକ ମାନଦେୟ ବନ୍ଦ କରାଗଲା।
କିନ୍ତୁ that's all right. That is all right. But there is no formal order of disengagement as such.
No.
Then what happened?
That order, madam, the petitioner has moved before this.
How is an appeal maintainable, sir? Mr. Das, against this order, how? He could have, a direction could have been issued to file a representation against this. Anyway, he has filed an appeal. Probably this court made that.
For the direction, the petitioner moved before the collector. And the collector on by the annexure 7 page 35 on 18/8/2016 director circular for inquiry and submission the report. The sub-collector has not entered the matter and submitted the report.
The sub-collector to issue notice to irregularities and take further course of action for disengagement following due procedure.
And the next day on 1/9/2006, without hearing, the collector directed the sub-collector to disclaim the petitioner.
Where is that order? Where is that order I've seen? Then
Against that order, the petitioner moved again before this by the annexure 8, page 36. And this Honorable Court has pleaded to pass the order on 17/10/2016 by page 38.
yes.
In the third para, the writ petitioner disposed of with an observation that in the event a show cause notice is issued by the sub-collector to the petitioner, opportunity shall be provided to her to file show cause. Thereafter, the sub-collector shall pass an order after offering opportunity of hearing to the petitioner till a decision is taken. The petitioner shall not be disengaged from the post of Anganwadi worker in respect of the Sahadia Anganwadi centers. Thereafter, without issuing any notice to the petitioner, the sub-collector has passed the order by the annexure 9.
Yes.
On 15/12/2016.
Yes.
Honorable Court directed the sub-collector will issue the notice and the petitioner will participate, and after hearing from the petitioner, he will pass the order. But the sub-collector, without complying that order and also without complying the law as per the Anganwadi workers relating to for disengagement, that the sub-collector is to issue notice, show-cause notice, thereafter he will pass the order. But in this case, the sub-collector has not issued any show-cause notice to the petitioner. And the sub-collector directed the CDPO to inform the present petitioner he will attend the sub-collector office. The petitioner attended the sub-collector office. The sub-collector, I will drop the case, he will sign in the blank paper. The petitioner sign in the blank paper. And he has used that, he has given the statement. And he has also admitted in the order that
this is an aspect this court cannot go into. If according to you, your blank, your signature on a blank page was utilized by the sub-collector behind your back, then you should have filed another application before the sub-collector saying that I have come to know that you have utilized my year.
But the sub-collector till date has without issuing any show-cause notice.
So, Mr. Mishra, I will not go into that aspect.
Without any show-cause, the sub-collector passed the order, and the sub-collector has categorically admitted that gone through the show-cause notice issued by the CDPO. He has admitted the CDPO has issued the show-cause notice. In page 40 last para.
Yes.
But this Honorable Court and the law specifically directed he will issue notice issue show cause. Thereafter we'll pass here and.
So who will, anybody else has been appointed in
No,
your
no,
place?
there is a stay order
Just-
by the Honorable Court.
Yes, Mr. Das.
In
How do-
paragraph 12 of the counter affidavit, your lordship will kindly find, after all those inquiry were held, she was asked to give a show cause. Paragraph 12. The show cause notice to the petitioner after receipt of the show cause on dated 18/11/2016, the petitioner, and after affording personal hearing to the petitioner, the sub-collector Jawasinghpur by his order dated 15/12/2016 has disengaged the petitioner from the post of Anganwadi worker as the petitioner refused to receive the said order. This was sent by registered post. The said order was served on her through Lotka by the office peon on 12/1/2017. That has been annexed as J/4.
Order was passed on 15/12/2016. The Lotka Jari was dated 12/1/17. That order he has communicated. That order I have challenged before this Honorable Court, that without issuing so called notice to the petitioner and violating this Honorable Court order and also the rules, the guidelines, he has passed that order. And I see for the moment, they are counter. The reply, the second additional reply, that is page 6
Of the
additional affidavit. They have stated that paragraph 6, additional reply, additional affidavit on behalf of the OP number 2 to 4, dated 8/11/2017, para 6. That with regard to the aberration by the paragraph 6 of the region, it is submitted that the petitioner has repeatedly said about the political leaders and confessed that she had not given eggs to the villagers. BJD, therefore, some persons created all type of problems. She is a volunteer. She has no authority to discriminate among the political parties and to render service accordingly. Why give the egg to the leaders? I will only give to the students. Those who are attend the Anganwadi center, as per the guidelines, he will supply the satwa and eggs, not the political leaders. And also, she does not give the ration to the helper.
You know, there are some certain allegations.
Allegations.
Mr. Das,
Sir,
the allegations need to be inquired into.
it has to be inquired into.
Inquired into giving proper opportunity of hearing, that's all. And the inquiry must be held at the level of the sub-collector. I'll direct that. That's simple, as simple as that. Without getting into all these pleadings and arguments, it simply say that this order, this court, this is a judicial order. This court has directed that you should issue a notice. You cannot really delegate it to somebody else. You cannot.
And also that reply, the additional so called, they filed some documents. Those who has given complaint against the petitioner, they have stated that we have received.
No, what we will do is, I will direct the sub-collector to conduct a fresh inquiry.
Yes,
By taking statements of persons or whatever the method that he may adopt.
But
Let him conduct a fresh inquiry. All right.
they the same CDPO, they have submitted the documents.
Presently, that CDPO will not be there. Somebody else will. It's a matter of record. Whether there is any complaint against you. If there is a complaint, supposing one Rama has given a complaint against you. So that Rama has to be examined in your presence.
Yes.
So that you can confront, you can cross-examine if so desire.
For the sake of argument, I have simply, those who have submitted a complaint against the petitioner, they have submitted a statement before the CDPO, and the CDPO had attached that documents that they have received the eggs and satwa.
Anyway, I will not get into the merits. I will simply refer to the order of this court, pass it, send it back, conduct a fresh inquiry.
And also he will pay with
The petitioner, while working as Anganwadi
And
worker,
another point, my lords, there are two Anganwadi centers in the same Sahara. The same CDPO has given charge to the petitioner for running of the both Anganwadi center.
Anyway,
Now they have stopped Saturday 1, but they have given to run the second Anganwadi center.
all right. The petitioner, while working as Anganwadi worker of Saharadia 1 Anganwadi Center, was called upon to hand over charges to the Anganwadi worker of the nearest center on certain allegations of misconduct. Stop. She approached this court in WPC number
5255 of 2016.
5255 of 2016, comma, which was disposed of by order dated
28/3/2016.
28/3/2016, granting her liberty to prefer an appeal before the sub-collector.
Before the collector.
Before the collector, Kono,
Yes.
Collector Jagsingpur. Accordingly, the petitioner preferred an appeal which was registered as miss case number 6 of 2016. By order dated 1/9/2016, the collector directed the sub-collector of Jagsingpur to issue show cause notice to the petitioner for the irregularities detected by him and to take further course of action for her disengagement following due procedure. Stop. The petitioner challenged such order before this court in WPC number
18083 of 2016, page 38.
18083 of 2016. Stop. By order dated 17/10/2016, this court disposed of the writ application inter alia, passing the following order. Inter alia with the following directions. Last paragraph ta quote kar do, page 38. The writ petition is disposed of with an observation that in the event of show cause notification. It is the petitioner's case that despite such order, no show cause notice was ever issued by the sub-collector. Rather, the CDPO was purportedly directed to issue notice. Subsequently, by order dated 15/12/2016, the sub-collector, basing on the so-called proceeding before the CDPO, directed disengagement of the petitioner. Stop. Said order is impugned in the present writ application. Stop. Though much has been pleaded and argued by both sides, this court finds that by order dated 17/10/2016 in WPC number 18083 of 2016, this court specifically directed the sub-collector to issue show cause notice and to grant opportunity of hearing to the petitioner before passing any order. Stop. Obviously, this court intended that the matter should be decided by the sub-collector and not the CDPO, who admittedly is an officer of a rank junior to the sub-collector. Stop. After going through the nature of allegations leveled against the petitioner and her reply thereto, this court is of the considered view that ends of justice would be best served if the matter is remitted to the sub-collector to strictly act upon the directions issued by this court earlier in WPC number 18083 of 2016. Stop. To amplify, the sub-collector shall issue show cause notice to the petitioner himself and grant reasonable opportunity to the petitioner to put forth her reply. Stop. Thereafter, the sub-collector may conduct necessary inquiry. Conduct necessary inquiry by examining relevant witnesses.
Complainants.
Eh?
Complainants.
With relevant by examining as how by examining the complainants and other witnesses. Stop. And basing on the result of such inquiry, comma, the final order shall be passed under due intimation to the petitioner. Stop. The whole exercise should be completed within a period of 2 months. From today, we'll say,
Sir.
from 2 months from today. Stop. Till such time, no coercive action shall be taken against the petitioner. All right.
The remuneration that is not paid.
If in the meantime, further, if the petitioner is found to have discharged her duties, in the meantime, since no formal order of disengagement has been passed against the petitioner, has been issued against the petitioner, comma, the authorities shall consider remunerating her Consider payment of her monthly remuneration as long as she is officially in service. That's it.
At not 17, already one para that para 6 can be put at that. The duty to supply the.
It will lead to unnecessary. So I have simply cleanly sabu kattedi koideli je se fresh inquiry karibe dekhibe. Till such time you will remain in the.
ଯାହା ପଚାରୁଥିଲି main issue ହେଉଛି ତାଙ୍କର ଯୁବକ ମାଗିଲେ ଅଣ୍ଡା ଦେଲାନି. Item 17.
Next.
This is matter next week as for.
Item 18.
Maybe.
This year has applied for the post of Shiksha Sir, and his candidature has been rejected. So he has approached for your lordship earlier, madam. Your lordship is directed to reconsider his.
Where is that order?
That is Annex 8.
Annex 8.
Yes.
What will it?
Page 52. All non-counsel for the petitioner, in the petition at the scope of objection following the instruction appearing in Annex 7 is permitted to appear before the competent authority and submit his objection, and the objection will be considered in its appropriate stage. It is made clear that in the event the selection process is already completed, the position of the last person selected involving category 2 shall be subject to the ultimate outcome and the consideration of the representation of the petitioner. The petitioner stands disclosed. Thereafter, I filed a representation along with that copy of the order, and that is my candidature. All the candidates have been rejected, including my candidature, and accepted. Page 55. That is under challenge. The following candidates applied for the post of Telugu Shiksha Sir in category 1 for the year 2016-17 in the district of Vaspati. Before this Hon'Ble High Court of Orissa, the Hon'Ble High Court of Orissa, white case numbers as mentioned against its constituent upon rejection of the applications. That is my the Hon'Ble High Court, while disposing of the above case, directed to competent authority to reconsider the cases of the petitioner in terms of the others. So, but paragraph 3, my lord, that is concerning my lord. Another candidate, Dali Purushottam, applied for the.
You are Dali Purushottam?
Yes, my lord.
Dali Purushottam applied for the post of Shiksha Sahib in category 2 for the year 2016-17 in the district of Gajpati has also prepared the writ before the Hon'Ble High Court of Orissa in WPC number so and so consequent upon rejection of its application. The Hon'Ble High Court, while disposing of the above case and dated 21/3/2018, have held that the petitioner had the scope of objection following the instruction appearing in the candidate's log in the OPEPA website to know the status of his application. He is permitted to appear before the competent authority and submit his objection, and the objection be considered in its appropriate stage. In portions of the order of the Hon'Ble High Court, all the 8 cases are had together in detail, being similar facts on 12/6/2018 in presence of all the candidates and the district project coordinator SSA Gajpati. The resolution number 25605 dated 26/12/2016 of the Government of Odisha School and Mass Education Department is the guideline for engagement of Shiksha Sahayak, and para 6.2 of the resolution relates to the eligible Urdu, Bengali, Telugu Shiksha Sahayaks. Candidate must have passed Urdu, Bengali, Telugu as the case may be as ML up to HF standard. Since their engagement is likely to be held in bilingual schools, candidates shall produce a certificate from the headmaster of the concerned school to the effect that he has passed HS examination in Odia medium. Candidates can apply either in category 1 or category 2 as per their qualification. The applications of all the above candidates were rejected as they could not produce a certificate from the headmaster of the concerned school to the effect that she has passed HS examination in Odia medium within the deadline. In the letter number of the State Project Director, Odisha Primary Education Program Authority informed the Technical Director NIC Bhubaneswar that some candidates applied for SS of city category are found rejected by the district and submitted the grievances. Considering their grievances, instructions have been issued to the DPCs not to reject their candidature and consider them. He therefore requested to reopen the data updation link for city category to facilitate the districts for making necessary corrections in the database. By 27/2/2018, published the revised merit list for city category for districts on 28/2/2018. The letter of the State Project Director of OPEPA is relating to providing facility to the district to further update of SS application for city category. I am not from the city category, I am from the BD category. The State Project Director, Odisha Primary Education Program Authority, in his letter number so addressed to the collector Gajpati, had clarified that letter number 1987 dated 26/2/2018 to the Technical Director NIC to reopen the data updation link of city category to facilitate all the districts for making necessary correction in the database, and it was nowhere mentioned to make the necessary correction, ignoring the restriction with regard to submission of Odia certificate for the Telugu Shiksha Sahayak candidates. Hence, the representation of the petitioners may be disposed strictly adhering to aforementioned government department resolution and clarification issued with reference to engagement of Telugu Shiksha Sahayak for the year 2016-17. This is the order. In foregoing discussion, the case of all the above candidates are found ineligible and they do not fulfill the criteria laid down in the resolution dated so of the Government of Odisha School and Mass Education Department. Then, my lord, I'm repeating the resolution, my lord. That is annexure 2, my lord. Your lordship may turn to page 37. That is the eligibility criteria. Page 37. Clause 6, eligibility. Category 1 is there, and I am coming under category 2. Then page 38. Graduation with at least 50% marks and 1 year bachelor in education, BD. That qualification I have. Graduation with 50 marks or so special education. Higher secondary +2 are equivalent with at least 50% marks, so. Pass in the Odisha teacher eligibility test, OTT category 1-2. Candidates must have Odia as ML up to class 10 or pass in Odia language test equivalent to matric standards conducted or declared equivalent by Board of Secondary Education, Odisha, except candidates as mentioned in paragraph 6.2. That is paragraph 6.2, your lordship on to. But 6.2. In order to be eligible for Urdu, Bengali, Telugu Shiksha Sahayaks, candidates must pass Urdu, Bengali, Telugu as the case may be as ML up to HSC standard. Since their engagement is likely to be held in the bilingual schools, such candidates shall produce a certificate from the headmaster of the school, concerned school, to the effect that she has passed HS examination in Odia medium. Candidates can apply either in category 1 or category 2 as per their qualification. So, for the requirement of passing the Odia standard, Odia medium, my lord, that cannot be, my lord, that cannot go together, my lord. Because a person who will in order to be eligible for Urdu.
What were you submitting just now?
I am submitting, my lord. If a candidate will go for Telugu education, my lord, like in Ganjam district, my lord, in Ganjam district, my lord, there is no facility of Telugu education for the Telugu persons living inside the Ganjam district. Even in Korapur district also, my lord, exclusively they cannot go for Telugu. Telugu system is also not there, but they are forced to go to the Andhra, my lord. For their education, my lord, they are forced to go to the Andhra. But in Andhra, so Odia is not available, my lord. So they have to appear with the for that reason, my lord, the class C is there. 6.C is that is 6.C category 2. Candidates must have Odia as ML up to class 10 or pass in Odia language test equivalent to matric standards. That I have completed. Yes, that is next 1 series, my lord.
6.2 there is a condition that you have to obtain
certificate from the headmaster
that
I have appeared the examination in Odia medium.
So you should have challenged the advertisement.
For that is, my lord, because of the page 31, my lord, you will submit.
I know. Unless you challenge that notification, how can you now?
Page 31, because for that reason, my lord, I have amended the writ application, my lord.
You have challenged it. Very good.
No, I am not challenging that, but to some extent, I have amended. Page 31, my lord, is your lordship time to that is the certificate issued by the Board of Secondary Education. Certificate that so possess knowledge in Odia equivalent to that of class 10 standard. So my amendment, that was allowed. The amendment was allowed. I have stated in paragraph 25A. I have inserted this, and I amended the third portion saying that this certificate may be considered for the purpose of 6.2.
But 6.2. Let us come to 6.2 again.
Yes. In order to be eligible for Urdu, Bengali, Telugu, Shiksha Sahayaks, candidates must have passed Urdu, Bengali, Telugu, as the case may be.
That you have passed?
Yes, I have passed. Since their engagement is likely to be held in the bilingual schools, such candidates shall produce a certificate from the headmaster of the concerned schools to the effect that he has passed HS examination in Odia medium.
No, this will not do. Your certificate will not do.
Yes, my lord.
That cannot cure this defect, Mr. Panda.
That cannot be cured.
You should have challenged it from the very beginning.
But so far the other districts,
you have a very good case. I tell you have a very good case. That this condition is restrictive. Is it not?
Yeah.
This is restrictive in so far as these Urdu, Bengali, Telugu candidates are concerned.
But there may be a purpose behind.
Why?
Odia medium may be required.
Because bilingual.
Yes.
You could have said that they may have a working knowledge of Odia. That could have done. But saying this seems to be a little bit contradictory, as he has pointed out, because there are no such schools in Odisha. So where from will they get those certificates?
They will be teaching in another language.
That's all right. Their Telugu Shiksha Sahayaks, they'll be teaching Telugu to Telugu students. Or any Odia person who wants to learn Telugu. Now the question is, if you insist upon a condition that they should have MIL in the concerned language, that is Telugu, up to HSC standard, and in addition to that, you say that it must be in a Odia medium school.
Both cannot go.
At least in Odisha, that is not practically appear to be possible. But then
in other districts,
other districts,
in other districts, Ganjam, Koraput, everywhere they have given.
You cite one.
I have in paragraph 10. I will, but they have not replied that.
No. You have to cite some documents. को दिखा दो.
दो नंदी कारण समाने काले के उतर में
ये. You must give a handle to the court to help you.
Paragraph 22. I have indicated, my lord.
This is the laboratory. That is just an aberrament. How have they replied? I'll then ask you to reply to this.
They have not given any reply.
Para 22. 22. All right. In course of hearing, the Pandal and counsel of the petitioner draws attention of this court to the averments made in paragraph 22 to the effect that candidates similarly placed as the petitioner in other districts have been held eligible for selection as Telugu Shiksha Sahayaks, despite having passed from Telugu medium schools. Stop. This court further finds that the counter affidavit the counter affidavit is entirely silent. Is silent with regard to this particular averment. So, discrimination. If you have relaxed the norms of your advertisement for some in some districts, this is a general advertisement for all districts. Now, in some districts, if you relax the norms, the other person can naturally claim Article 14, the benefit of Article 14. So that is the only way he can now enter into the. There's a small opening. Try to enter into that.
Otherwise, I will challenge that notification.
It is too late now to challenge. Having participated, you can now turn around to challenge it.
That averment, that reply they have also said.
Obviously, having participated, you cannot challenge it again. So the only way you can succeed, if at all, is by drawing parity with those persons from other districts, maybe Navarangpur, Gajapati, Hitapare. Ganjam. You are from?
I am from Gajapati. I am from Ganjapati.
No, this petition is from?
Yes, I am from Ganjam, but I prefer Gajapati.
Anyway.
Because of the vacancy, availability of vacancy.
Anyway, conflict has not been answered. Since the petitioner has raised the plea of discrimination, citing the above, it is necessary to know the response of the state in this regard. Stop. The state council is therefore directed to obtain specific instructions as to if any person identically / similarly situated as the petitioner has been accepted as Shiksha Sahayak, as Telugu Shiksha Sahayak in any of the districts of Orissa. Place this matter on 25th September. Yes.
Last occasion of lot to directed to take instruction. We have challenged the petition is a Jogana Sahayak.
You wanted to file an affidavit, Mr. Das? Are you ready with that affidavit? What, 14.8, you said that you will file an affidavit, and today you said you are not ready.
I've got a chance here.
With cost? No, 10,000 rupees cost. I'll impose cost.
Next week.
To be realized from the salary of the officer concerned, was delayed.
If in the next chance he fails, then.
No, 10,000 I actually calm kar deli. I actually meant another zero. Lock it on. When I was law secretary, Supreme Court imposed a fine of cost of rupees 10 lakhs for not filing counter in time. To be further recovered from all the officers concerned. One officer from the law department was also had to pay the money, and I had sworn the affidavit, being the secretary of the department. And thereafter, we evolved a policy as to kaha pakar ke din file rahibo, including the minister. Kaha pakar ke din rahibo.
7 days.
Jodi 7 days ru 8 din hala tame ta saite file ta pathabo explanation saite pathabo kahi 8 din hala boli. That we did, but se kon korthum koi peribini, but that is what we were following.
This case I would pay for another 7 days, that's all.
As requested by Sri A. Das Learned DGA, list this matter next week. Counter affidavit will be filed in the meantime positively. Remind me on that day. If he doesn't file, remind me what I said today, so that I will impose cost.
I am for opening of time.
Yes.
Item 20.
Item 20.
20, my lord. I pray to withdraw the writ application of delivered to file a better application, my lord. There are some subsequent facts
which also needs to be adjudicated.
Correct. Permitted to withdraw with liberty to file a better application.
Item 21. Regulars. Item 21 can have next week, my lord.
Correct. Next week is prepared for.
Interim order to continue.
Interim order to continue.
Item number 23.
22 तक कहाँ लगी?
Mr. Mishra.
Item 23, yes. Is this matter before any other bench with permission of Honorable the Chief Justice as I am concerned?
24.
Petitioner is the wife seeking direction to transfer the divorce proceeding which was been filed by the husband from the court of family judge Kotak to
2017 matter notice है ही नहीं.
notice has already been issued and
Notice has been made sufficient.
my lord, it did not return. But the opposite
Stay
party
petition.
appealed before the London court below and the stay petition, stay order has already been filed and the divorce proceeding already stayed.
Yeah, but there's no endorsement regarding no service of notice. You take fresh notice. Otherwise, how will we dispose of? You take fresh notice. You.
So file the order, certified copy of the order before the London Tribunal Court and.
No, that's true. That's true. But for disposal of this case, we will need the either the notice is served or
Fresh notice.
take fresh notice. Office note does not indicate whether notice on the opposite party was served or not. Hence, issue fresh notice by speed post, fixing a short returnable date. Requisites be filed within 3 working days. List this matter on 23rd October. Is there any interim order? Interim order to continue.
45.
25. Pass over.
26.
Last occasion, let's say we asked for any chance of settlement. Due to the past experience and long separation of 12 years, the wife is not interested.
Both the matters will come to Kotak.
ଗୋଟେ ଅଛି ଆଠଗଡ଼ରେ ଗୋଟେ ଭଦ୍ରକରେ and the husband is living at Bhubaneswar.
No, Divyant Bhadrak already left the job, Bhubaneswar, service.
No, this is a case for transfer of from Bhadrak to Athagad. Bhadrak to Athagad.
Another matter is
ତା ସାଙ୍ଗେ ଅଛି ଆସିଛି.
37 টাকা.
So what he is suggesting is good also if you can bring it to Kotak.
Both the matters may go.
Both the case ne jant होला 26 and 27. TRPC 64 of 2019 has been filed by the wife of opposite party seeking transfer of MAT case number 304 of 2018 pending in the court of Leonard Civil Judge Senior Division Athagad to the court of Leonard Judge Family Court Bhadrak. TRPC number 152 of 2019 has been filed by this is another lady.
Yeah, actually in-laws माने पक्ष होई जाइछन्ती सेही माने फाइल करछन्ती old in-laws.
Filed no, that is Savita Mahapatra, aged 34 years. Sorry, I'm sorry. Filed by the in-laws of opposite party number 1 for transfer of MAT case number 304 of 2018 from the court of Leonard Civil Judge Senior Division Athagad to the court of Leonard Judge Family Court Bhadrak. You have also wanted to come to Bhadrak? No.
My case.
is
You want that my case be transferred?
So 64 ta kahara?
64 ta wife ro.
So 64 in you wanted
Actually divorce case is pending at Athagad and 69 application at Bhadrak.
so you wanted to be transferred to Bhadrak. That is your application.
To Athagad. Bhadrak case ta Athagad को आसो हमें चाहूची. अब in-laws माने चाहूचन जे
अच्छा ताले सेटा भूल हे गेला लिखंतु प्रथम टर लिखंतु ह लिखंतु prayer for seeks transfer of civil proceeding number 8 of 2019 pending before the Judge Family Court Bhadrak to the court of Civil Judge Senior Division Athagad. आरटा हला से जो मैट केस नंबर 304 of 2018 लिखा है by the in-laws from Athagod to Bhadrak. In course of hearing, counsel for the parties submit on instructions that it would be convenient if both the cases are transferred from Bhadrak and Athagod to Cuttack. Both the cases are transferred to Cuttack, as it would be more convenient to both of them. Sara. Considering the submissions as above, both the transfer applications are disposed of in the following manner. One, Amoko case number is transferred, directed to be transferred from Ethiopia. Yes. Ditanga Koto question. Arata mat case number 304 of 2018 pending from Omoko shall be transferred to Cuttack. Judge family court Cuttack. Arata Simti pending before Omoko Athagod shall be transferred to Cuttack.
Where the date may be fixed for appearance of
Yes, that will be fixed. Yes, it after receipt of records, the judge family court Cuttack shall issue notice. That amar kora jayega.
I don't know 28.
Pardon, one prema like item 25 minutes.
No.
In this case, I am appearing for opposite party. And
Sri Amar Balananda, advocate and associates have entered appearance for opposite party number?
opposite is
No, this whole opposite party. They're filing Bakalak. Same be kept on record. Yes.
Here, your lordship, the petitioner is the wife seeking transfer from family court Baleswar to Baripada because there are another DV case filed by the present petitioner also pending. And the CP case filed by the husband under section 13 of Hindu Marriage Act, your lordship. At present, wife.
Any chance of settlement? Any chance of settlement? Mediation?
None.
Mediation? Both? Cuttack? At Cuttack High Court mediation center? All right. Mediation for date fix karo.
6 November.
6th November. In the meantime, mediation by order of Bakata Hijo.
Interim order mean.
Interim order to continue.
Item number 30.
Yes, item 30. Who's for the petitioner?
I'm for the petition.
You are for the petitioner?
Petitioner.
Tell pass over.
Yes, sir.
Is it Tilagi? Or Tila? Item number 30. Petitioner is not there. What was the order? Yes, who is the secretary DLSA? Please unmute yourself. Please unmute yourself.
My lord,
My
lord, the petitioner is present here.
Yes, you are the secretary DLSA?
Yes, sir.
What is your name?
My lord, Debasri Sahu.
Yes?
Debasri Sahu.
Debasri Sahu. Yes. You have you identified her? Does she carry any documents of identification? Have you checked them?
Yes, my lord, her Aadhaar card is with me.
The original Aadhaar card, you can return the original Aadhaar card after keeping a signed copy of the signed Xerox copy of it. Okay. Please ask her. Her name is her name Pratima Behra.
Yes, my lord.
आपका नाम प्रतिमा बेहरा
sir.
आपण मीडिएटर को पाखरे कहिथिले जे आपण कोनसी केस फाइल करना हथि बोली ट्रांसफर एप्लीकेशन आगे
May I speak something?
यस प्लीज
My lord, she doesn't understand actually. से काली my lord कहिले आसिकी कि मु बुझी पालिनी ट्रांसफर माने कोन मु कहि देथिली. My lord, she has agreed that she has filed a transfer case.
ओके ओके
shown the petition with her signature and she agreed that she has signed.
All right. ଆପଣଙ୍କ ଓକିଲ କିଏ ଆପଣ ଜାଣନ୍ତି?
ଓକିଲଙ୍କ ନାଁ କଣ? My lord, ତାଙ୍କ ଭଉଣୀ ଆସିଛନ୍ତି ସେ କହିପାରୁଛନ୍ତି she doesn't understand actually. ମାନେ she doesn't even remember his advocate's name.
Okay, all right. That's all right. That's all right. That's all right. As directed, the petitioner Pratima Behra is present virtually from Barampur. Stop. Ms. Debasri, कौन कहले आपन नाटा?
श्रीमती देवश्री साहू.
Ms. Debasri Sahu, the secretary, DLSA Ganjam, is also present virtually and identifies the petitioner on the basis of the original Aadhaar card furnished by her. Stop. She is directed to keep a signed Xerox copy of the Aadhaar card and to transmit the same to this court for being tagged to the case record. On being asked, the petitioner Pratima Behra submits that she could not understand the nature of the proceedings before the mediator, for which she inadvertently mentioned that she had not filed the transfer case in question. Stop. However, she reiterates that she has in fact filed the present transfer application to her counsel and that she would like to pursue the same. ଆପଣ ଏ କେସ୍ ଚଲେଇବାକୁ ଚାହୁଁଛନ୍ତି ତ? She would like to pursue the same.
Permitted to withdraw.
Yes?
I don't want to continue.
Just a moment, Mr. Mishra, just a moment. ସେ ବୁଝିନଥିଲେ ସେ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ କିଛି କହିନାହାନ୍ତି.
Mediation because I faced there are lots of trouble since it 1 month. I am facing various problems. So I don't want to continue. That is my.
That's all right, all right, all right, all right. ଆପଣ ଯାହାଙ୍କୁ ଓକିଲ ଦେଇଥିଲେ ସେ ଆଉ ଆପଣଙ୍କ ପାଇଁ କେସ୍ କରିବାକୁ ଚାହୁଁନାହାନ୍ତି ଆପଣ ଅନ୍ୟ କାହାଙ୍କୁ ଓକିଲ ଦେବେ ନା ଆପଣଙ୍କ ତରଫରୁ ଲିଗାଲ ଏଡ୍ ବି ଦିଆଯାଇ ପାରିବ? ପ୍ଲିଜ ଆସ୍କ ହର.
My lord will provide counsel.
All right, she wants to pursue the application. At this stage, Sri Malay Kumar Mishra, learned counsel, submits that he would not like to conduct the case on behalf of the petitioner any longer, and that his power may be withdrawn, permitted to be withdrawn. Stop. On being asked, the petitioner expresses her inability to engage any other counsel, for which the DLSA, the secretary DLSA, no, we can engage somebody from our court, for which the stop. As such, the secretary High Court Legal Services Committee is directed to engage a lawyer, or you can engage somebody from there.
Yes, my lord.
DLSA setu karibata subidha ho na kamo. For which the secretary DLSA Ganjam is directed to engage a lawyer from the legal services panel to represent the petitioner in this case. List this under intimation to this court. List this matter on 25th September. Yes. Is there any interim order? Achha, sir, ठीक है.
Item 31.
In pursuant to your lordship's direction, dated 24/7/24, mediation is under progress. Let it come.
The interim report of the mediator indicates that the next date of mediation is fixed to 28th of this month. Hence, list this matter October
9th October.
9th October.
Interim order.
Interim order to continue.
For the case.
32 same.
Item 33.
33. Lordship may free one lord, lordship may refer the matter to mediation. It was said that the earlier case filed by your client seeking transfer of the domestic violence case pending before the has been dismissed for non-removable of defects and that he intends to file a fresh application. Therefore, seeks an adjournment. Okay. All right. Sri Mahanti submits that his client has filed TRPC number.
TRP, D number ties,
Please?
26817.
He has filed a transfer application for transfer of the domestic violence case from Barampur. Stop. Insofar as the present case is concerned, in course of hearing, it is submitted by counsel for both sides that the matter can be attempted to be settled through the process of mediation. Mediation order High Court mediation settle. कर देगी date करो.
6th November.
Huh?
6th November.
All right, place this matter on 6th November, interim order. Earlier also there was no appearance from the side of the opposite party. So as such, the transfer application is taken up for hearing. Allow for it, huh? Allow.
Item 35.
Mediation date is 17th September.
I am on VC, your lordship, item 35.
Oh, yes. Yes.
Item 35, your lordship. Next mediation is on 17th September.
All right. The report of
Okay.
the mediator indicates that the next date of mediation proceeding is fixed to 17th. Hence, raise this matter on 25th September.
Item 36.
36.
The lordship, I am appearing for the opposite party. The client is staying abroad, my lord. So do not be contacted for conciliation, my lord. That's was directed, if there is any chance of conciliation. We tried our best, but it seems that he is not coming recently. So let it come 2 weeks after, so that we'll take instruction.
Actually, he
After
can.
his
No,
arrival only. It
no,
can
no,
be-
I can adjourn it, but he can also appear virtually if he so wants.
That is also possible. I will
Virtually before the mediator also.
report immediately.
He can appear virtually before the mediator. What is wrong in it? Sri Achari, Learned Counsel for the opposite party submits that his client is presently residing outside the country and therefore he requires some time to obtain the necessary instructions. Place this matter. November.
6th November.
Eh?
6th November.
6th November. Interim order to continue.
Intimate time petition to be filed and it will be urgent.
Stay good.
Stay.
Stay good.
Item 37.
May I please your lordship? Your lordship, the petitioner wife is seeking for transfer of a civil proceeding from family court Raulkala to learned civil judge senior division Champua district Keonjhar. There is a matrimonial dispute under section 9 of Hindu Marriage Act is pending in family court Raulkala. Distance between Raulkala to Champua approx 150 kilometers.
You are appearing for the husband. Any chance of settlement?
Settlement तो council से तो appear हले किंतु expert है कि appear हले नहीं जितने notice पाई जंदी appear हले नहीं और काली argument थिला judgment पे ही अच्छी next
Judgment में अच्छी केस है. इस स्टेज कौन ट्रांसफर हो? इस स्टेज ट्रांसफर कौन हो? In course of hearing, it is stated at the bar that the case sought to be transferred is now posted for pronouncement of judgment. In such view of the matter, I am not inclined to entertain this application, which is therefore dismissed.
38.
Ultimately on the Netflix. The prosecution they have declined ballot examination of AIP.
Declined.
Declined.
Very good.
Declined and investigating officer has been examined for last.
and it is posted for 313, my lord.
313. Then you will have to appear.
My lord?
You will have to appear for 313.
Yes, accused will appear there. But
Yes.
the reasons best how they have kept my lord, the
Much
petition-
ado about nothing.
My lord, he has categorically stated in his statement 2 days back.
On 27th, I have taken instruction from the IO that several times summons has been sent, but whereabouts has not been known.
All right. I will not blame you. No, it is up to you. The question is.
SP also it has been ascertained.
Anyway.
SDPO who has been examined as a witness, he has stated that I verified that this so-called walkie-talkie was purchased from Flipkart, and we also ascertained from the Flipkart authorities that from this number order was placed, and it has been it has not also stated specifically that it has not been used.
No, I will just simply ask the court below to confirm whether these, let the court below inform, let it come next week. You continue on bail and I will make it absolute next week. Sri D.P. Dhara, Learned Senior Counsel, appearing for the petitioner, submits on instructions that the witnesses named Mr. A and Mr. B have been declined to be examined by the prosecution, and that the investigating officer was examined. Stuff. The matter is now posted for recording of the statement of the accused under section 313 of CRPC. Oh, it is a Puruna law answer, 313 of CRPC. Learned, the court below is directed to submit the present status of the case to this court by email. Please this matter on 13th September. This order be communicated to the court below forthwith. The interim bail granted earlier shall continue till the next date. On that date, we will make it absolute. After receiving an official copy of the order of the court, then yes.
I will fix up a date for hearing.
13th
13th. Yeah.
Interim order of bail, the interim bail granted shall continue till 16th.
16th is holiday.
No, 16th how? 16th or 17th. So on 13th, if it is necessary to be extended, it will be extended, or if it is made absolute also, it will be made absolute. It is said much ado about nothing. There is a story by William Wordsworth. Or I think Shakespeare probably, Shakespeare. Much ado, A-D-O, about nothing. तार गोटे corresponding माने कालिदासंकर भी अछि इंडियन शेक्सपियर या अजा युद्धे ऋषि श्राद्धे प्रभाते मेघ आडंबरु दाम्पत्य कलहमेव बहु आडंबर लघुक्रिया ये सब जिनस बहु आडंबर लघुक्रिया भाई मिस्टर ए एंड मिस्टर बी कहि कि जा कले हैला प्रोसीजर यस
Your Lordship, can I say your Lordship's order? Running page 8, your Lordship. While granting the bail, your Lordship, last line, this order shall operate only if the injuries are found to be simple in nature.
को जगह अछि
गोटे इंजुरी अछि सिंपली गोटे इंजुरी ग्रेव अछि
नो आपन को तो टाइम टू सरेंडर दिया हितला
सेटा बा पढिले आज्ञा सेई जो लास्ट
Sound to be simple in nature. All right.
Your Lordship's order.
Considering the submissions, order dated 18/10/2023 is modified to the extent of deleting the last sentence of paragraph 5.
This paragraph 5.
What?
सेटा गोटिए से ग्रेव
Sorry, order ta excellent.
delete paragraph 5.
डेरीटे बुझिला बेलू कचेरी बरखास्त होई सरता
Item 40.
That's all.
Item 41.
Can be modified and close item serial number 5 minutes. The condition has imposed petitioner is the instructor in the police miller.
Condition number 1 was
One may kind of the representation petition has been Condition one, he
I said till the end of election. During such period, the petition may be allowed to be represented through counsel.
police officer,
Hmm.
due to law and order, he could not.
कौन law and order?
Condition number 5 I मतलब.
5 तो नहीं बिल्कुल.
Hello?
1 अच्छी, 2 अच्छी.
No, 5 I say, he shall personally appear before the court in session over the matter each of date of posting. No appearance, representation for with counsel by the allotment. That is the difficult part of the inspector's petition.
All right. It is submitted that the petitioner is a police officer and is usually deputed to several duties, including law and order duties. As such, it is proving difficult for him to physically appear before the court below on each date of posting of the case. Stop. Considering the submissions as above, the condition number 5 bracket I of order dated 22/2/2024 is modified to the extent that the petitioner may be permitted to be represented through his counsel on the dates of posting of the case, except when his personal attendance is considered necessary by the court.
Item 42.
I may pardon my lord. Time may be extended. Item 39.
1 week time.
Yes, sir.
1 week further time is allowed. According.
I pray your lordship urgent certified copy along with a copy of the order dated 18/10.
Urgent certified copy of the order be granted.
Obliged.
And instead of filing requisites by speed post, I filed a requisite by registered post ID.
Right.
And we kindly be
Requisites,
accepted and notice be issued to
requisites filed be accepted and notice be issued as directed, fixing a short returnable date. Is this matter on
9th October.
9th October?
Item 43.
In 43, your lordship, in a connected matter yesterday, the counsel for the petitioner has submitted that the accused person has been acquitted in the case, whereas the status report of the online status report shows that the matter is pending and it is posted to 16/9/2024. So the status report may be called for, your lordship.
All right. There seems to be some confusion regarding the status of the case before the court below. The court below is therefore directed to submit a report regarding the status of the case. Place this matter on 18 September. This order will be communicated to the court below forthwith.
Obliged, lord.
Yes, please.
May I please?
Yes, please.
The case where petition was remanded on 27/4/24 on the allegation of commission of offence punishable on section 457, 380 and 431, section 413, section 34 of the Union. Admittedly, so far this case is concerned, nothing was seized. What happened? In a earlier case, the petitioner was arrested on the same self of offence in respect of another PS. And some seizure was effected from the godown because he is a covert man. Some articles were seized from him. That seizure list was utilized by different police stations and thereafter remand being issued. And the earlier case in respect of which the seizure was effected, he was granted bail by this honorable court. And so far in this case, one of the co-accused has also been released on bail and charge sheet has been submitted. So these are the matters.
This is the remand case, my lord. And
The petitioner is in custody since
27/4/24.
27. 27/7. 27/7/2024. so 27/4/2024, being remanded in connection with such and such case. As per the FIR, some unknown culprits committed theft of temple to
Yes.
committed theft. Mandir chori kale.
ସେଇଥିପାଇଁ ତ ଏତେ
ଘଣ୍ଟା ଆଉ କଣ ସବୁ ରିକଭରି ହେଲା 3-4ଟା ଜିନିଷ।
Outside, I would tell you something else that you can understand what I'm trying to say. Name of the look at the name of the petitioner.
Yes.
I will not say anything.
Mahadeva Mandir.
I know everything. That's why I have not stated anything what is the allegation and who is the petitioner and whether I should appear.
No, ସେଥିରେ କିଛି ନାହିଁ।
But Mahadeva Mandir.
ସେଥିରେ କିଛି ନାହିଁ। This is purely on a lighter vein. Nothing. This court cannot take such a view at all. Committed theft of ornaments and other utensils of a temple. In course of investigation, no one has been named in the FIR. But in course of investigation, certain allegedly stolen articles were found in the godown of the petitioner, who is said to be a scrap dealer. Stop. On such basis, he was remanded in this case. Sri S.C. Mahapatra, Senior Counsel, appearing for the petitioner, submits that the petitioner has been implicated only on suspicion, as he, being a scrap dealer, accepts all sorts of objects sold by others, and therefore he cannot be expected to verify the source of all such articles dealt with by him. Moreover, the co-accused, Akhtar Khan, has been released on bail as per order passed by this court, as per order passed by a coded bench of this court in BL appeal number 5902 of 2024. Stop. The petitioner stands more or less on the same footing. Stop. That apart, charge sheet has already been submitted. Para. Taking into consideration the submissions as above, the period of detention in custody, and the fact that charge sheet has already been submitted, I am inclined to allow the prayer for bail. Let the petitioner be released.
From 45.
Yeah. The petition in custody since 27/7/2021, my lord.
Yes.
Almost 3 years. The quantity involved is 720 kg.
Dhobbu Pangi.
And you also see at page 15 of the charge sheet, in fact, one motorcycle.
How reject ହେଇଛି এটা second time reject ହେଇଛି no second time the interim bail ଦିଆଯାଇଥିଲା
yeah, it was for 6 weeks ଦିଆଯାଇଥିଲା.
Yes,
I filed another
you filed from 27
27/7/2021 custody,
and in the meantime 3 of the independent witness to search and seizure is examined. They did not support the case of the prosecution.
You have the depositions?
I have already annexed to the bail petition. Annexed 3 series these. Start from page 32 to
independent witness, they turned hostile, my lord.
You filed an IA?
Yes, madam. 1028 up to 2020.
Therefore, interim bail has been made on the ground that the petitioner's wife is suffering from breast cancer and is undergoing treatment at DHS Malkangiri Hospital and Acharya Harihar Cancer Institute at Cuttack. It is submitted that there is no other person available in the family to take care of. Yes, madam.
One second, please.
It is therefore submitted that it is submitted that there is no other person available in the family. Stop. Taking note of these facts, this court had granted him interim bail for a period of 2 months. Stop. He surrendered to custody in time without misusing his liberty. Stop.
Initially granted for 3 months, sir.
3 months. Yes. Further, Now, presently, the petitioner is suffering from stomach pain and being admitted to the hospital was found to be suffering from hernia, which was operated, and he was discharged on 6/7/2024. Since he has been advised bed rest and further treatment, it is prayed that he may be released on interim bail. Learned State Council, though opposes the prayer for interim bail, yet fairly submits that looking at the grounds raised, the court may pass appropriate orders. Considering the submissions as above and the grounds cited by the petitioner, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 3 months.
Much obliged.
Bail application taku pending rakho. List the bail application for hearing on 3 months for November, December. 23rd December. 23rd December to छुट्टी ही तो.
23rd vacation.
छुट्टी क्या करो? 25 छुट्टी. On 23rd December. All right.
Item 46, may proceed.
कौन चिट्ठी आसी?
Black key, man.
Black key. One witness has been examined out of 22 charge sheets. The case is written. The court below has intimated that only 1 out of 22 CS witnesses have been examined.
Charge sheet 26.
22 22 CS witnesses. 2 CS witnesses have been examined so far. Further, the petitioner further ये कौन अच्छी?
US quantity man from Jharkhand.
Jharkhand रे कौन हो?
Your Lordship, while man calling for the status report on 7/8/2024, Your Lordship specifically requested for to send the instruction. One person has been granted interim bail. Whether he is appearing or not, Your Lordship specifically directed.
Further,
I got instruction that
further the court below has also intimated that the co-accused Raman Kumar Raut, who was granted interim bail, has been appearing before the court regularly. Stop. Learned State Council, it is therefore submitted that the petitioner may be released on at least on interim bail. Stop. Learned State Council opposes the prayer on the ground that the petitioner belongs to the state of Jharkhand, and if released, he may not appear before the court below to face trial. That is the problem. What can be done?
That Raman Raut, who was granted interim bail, he is also man of Jharkhand.
Bihar.
For that reason, Your Lordship, no Jharkhand.
Alright.
Here I have annexed my lord, page 10, my lord. Both are
At present Jharkhand. Bihar address दिया ही है at present Jharkhand.
Bokaro, both are of the same PS.
This court observes that the co-accused also belongs to the state of Jharkhand. The petitioner has been in custody since
8/7/2021.
8/7/2021. There is no possibility of the trial being concluded in the near future. Taking note of these submissions, this court is inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 2 months. On such terms and conditions, including the condition one, he shall furnish 2 local sureties. Next, he shall furnish his telephone number and contact address to the court as well as the IU before being released on bail. Next, he shall appear before the court below on each date of posting of the case without fail. This is the bail application for hearing on by the Dimas Pare. 20th November.
Item 47.
He better appear. If he doesn't appear, the bar will suffer. The entire bar will suffer.
Absolutely. 47 pass over it can be only up over.
47
Right.
pass over.
Item 48.
Pass over. बहुत pass over.
49.
But so the CD was called for that.
CD.
Petition is a marriage sister-in-law. And saying separately that charge sheet under section 306, 304B, along with the husband in custody. The cause of death is marriage, suicidal hanging marriage by means of a sari.
Earlier I have rejected.
Yes, my lord, on merit, my
It's a
lord.
case, no, it's a case of.
It's the
302,
second time.
Just a minute. It was earlier 302, 304B. And now charge sheet under section 306, 304B, 300 is not there. The fact, my lord, one thing I must submit for lordship, my lord, the date of occurrence, my lord, so it's a silly, my lord, quarrel in the family.
Let us first place the FIR, then we will see.
Yes, my ମୋର ନାମ ରବି ମହାପାତ୍ର ସୁହାଂଶୁ ମୋର ଝିଅ ମମତା ମହାପାତ୍ର ବୟସ ସୁହାଂଶୁ ଗତ 21-25-2023 ତାରିଖରେ ବୈଦିକ ରୀତିନୀତିରେ ବିବାହ କରିଥିଲୁ। ବିବାହ ସମୟରେ ଆବଶ୍ୟକୀୟ ଆଶବାସ ପତ୍ର ସବୁ ଦେଇଥିଲୁ। ବିବାହର 2 ମାସ ପରେ ମୋର ଝିଅ ମମତା ମହାପାତ୍ର ଫୋନ କରି କହିଥିଲା ମୋର ଶାଶୁ ନଣନ୍ଦ ସ୍ୱାମୀ ଅଧିକ ଟଙ୍କା ପାଇଁ ମେଣ୍ଟାଲ ଫିଜିକାଲ ଟର୍ଚର କରନ୍ତି। ଝିଅ ମତେ ବାରମ୍ବାର କହିଥିଲା ଏହି ବିଷୟରେ ଶେଷକୁ ସେମାନେ ଝିଅକୁ ଶାଶୁ ନଣନ୍ଦ ମିଶି ଫ୍ୟାନରେ ଝୁଲେଇ ଦେଇଛନ୍ତି। 18/8/23 ସକାଳୁ ମୋର ସମୁଦି ଫୋନ କରି ଏହାକୁ ଜଣାଇଥିଲେ ମୋର ଝିଅ ସୁଇସାଇଡ କରିଦେଇଛି ବୋଲି, କିନ୍ତୁ ଆମେ ଝିଅ ପାଖକୁ ଶୁଣିଲୁ ଯେ ତା ଶାଶୁ ନଣନ୍ଦ ବହୁତ ପ୍ରକାର ଟର୍ଚର କରୁଥିଲେ, ଶେଷ ମାରି ଦେଇଥିଲେ। ଆମେ ସମସ୍ତେ ପରିବାର ସହ ଦେଖିଲୁ ମୋର ଝିଅ ସେକ୍ଟର 4 ଫ୍ୟାନରେ ମରି ଝୁଲୁଛି। ମୋର ଝିଅର ଶାଶୁ ହେମଲତା ମହାପାତ୍ର, ନଣନ୍ଦ ସୁଜାତା ମହାପାତ୍ର ଅଟେ। And also kindly turn the charge sheet. I have the
Lordship,
meantime, Lord.
copy of the charge sheet I have supplied. That
state,
5-6 lines, Your Lordship. She is the main that sister.
No, that Rabi Mahapatra in the one statement she has stated, my lord. ମୋର ଝିଅ ମମତା ମହାପାତ୍ର the statement I am reading, the informant. ମୋ ଝିଅ ମମତା ମହାପାତ୍ର ବିବାହ ସେକ୍ଟର 4 ରାଉରକେଲା ବିଶୋଧ ମହାପାତ୍ରଙ୍କ ସହିତ ହିନ୍ଦୁ ରୀତିନୀତିରେ ଚଳିତ ବର୍ଷ ଜାନୁଆରୀ 25 ତାରିଖରେ ହୋଇଥିଲା। ଆମେ ଯୌଥ ପରିବାରରେ ଅଛୁ। ମୋର ବଡ ଭାଇ ହରି ମହାପାତ୍ର ଘର ସବୁ ଭଲ ମନ୍ଦ ବୁଝନ୍ତି। ଭାଇ ଝିଅର ବିବାହ ସମୟରେ ଆବଶ୍ୟକୀୟ ଆସବାସ ଜିନିଷପତ୍ର ସୁନା ଅଳଙ୍କାର ଫର୍ଣ୍ଣିଚର ଏବଂ ନଗଦ 1 ଲକ୍ଷ ଟଙ୍କା ଦେଇଥିଲେ। ବିବାହର 2 ମାସ ପରେ ମୋର ଝିଅ ମମତା ମହାପାତ୍ର ଫୋନ କରି କହିଲେ ତାର ଶାଶୁ ହେମଲତା ମହାପାତ୍ର ନଣନ୍ଦ ସୁଜାତା ମହାପାତ୍ର ଅଧିକ ଯୌତୁକ ତଥା ସୁନା ଅଳଙ୍କାର ଆଦି ଦାବି କରୁଥିଲେ। ଝିଅ ମୋର ମାଆକୁ ସବୁ ଫୋନରେ ଜଣାଉଥିଲା। ଝିଅର ଶାଶୁ ନଣନ୍ଦ ଯୌତୁକ ପାଇଁ ବାରମ୍ବାର ଏଣୁତେଣୁ କହୁଥିଲେ। ଝିଅ କାନ୍ଦି କାନ୍ଦି ମୋ ମାଆକୁ କହୁଥିଲା। ଝିଅ ଆମ ଘରେ ରହି ଦ୍ୱିତୀୟ ଥର ଶାଶୁ ଘର ଆସିବା ସମୟରେ ଝିଅକୁ 2ଟି ହଳ କାନ ଫୁଲ, 1 ମଙ୍ଗଳସୂତ୍ର, 1 ଲକେଟ ଲଗା ଚେନ୍, ଟଙ୍କା 10,000 ଦେଇଥିଲୁ। କିଛି ଦିନ ପରେ ଜ୍ୱାଇଁ ବିଶ୍ୱଜିତ ପାଖକୁ ବରାଣୀ କେଉଁଝର ଯାଇଥିଲା। ଜ୍ୱାଇଁ ବିଶ୍ୱଜିତ ଟ୍ରାନ୍ସଫର ପାଇଁ କିଛି ଦିନ ହେବ ମୋ ଜ୍ୱାଇଁକୁ ରାଉରକେଲା ସେକ୍ଟର 4 ତାଙ୍କ ବାପା ମାଙ୍କ ଘରେ ଛାଡ଼ି ଦେଇଥିଲା। ଜ୍ୱାଇଁ ବିଶ୍ୱଜିତ ମଧ୍ୟ 50,000 ଟଙ୍କା ଆଣିବା ପାଇଁ ମମତା କହିଥିଲା। ମମତାର ବଡ ବାପା ଫୋନ କରି ଜଣାଇଥିଲା ଯେ ଜ୍ୱାଇଁ 50,000 ଟଙ୍କା ମାଗୁଛନ୍ତି ଏବଂ ତାର ବଡବାପା ପୁଅ ଆଲୋକ ମହାପାତ୍ର ଜ୍ୱାଇଁଙ୍କୁ 14/8/23 ତାରିଖରେ 10,000 ଟଙ୍କା ଦେଇଥିଲା। ମାନେ ଗତ 15 ତାରିଖ 2023 ସମୟରେ ମମତାର ଶ୍ୱଶୁର ପନିର ଆଣିଥିଲେ। ପନିର ନ ପାଇବାରୁ ତାର ଶାଶୁ ପରୋକ୍ଷ ଭାବେ ବହୁ ମମତାକୁ ଏଣୁତେଣୁ କହିଥିଲେ। ମୋର ଝିଅ ମମତା ସେଇ କଥାକୁ ପ୍ରତିବାଦ କରିବାରୁ ତାର ଶାଶୁ ତାକୁ ଗାଳି ଦେଇଥିଲେ। ଶ୍ୱଶୁର ତ୍ରିନାଥ ମହାପାତ୍ର ତାଙ୍କ ସ୍ତ୍ରୀ ପ୍ରତିବାଦ କରିବାରୁ ହେମଲତା ମହାପାତ୍ର ରାଗି କରି 16 ତାରିଖ ଘର ଛାଡି ଝିଅ ସୁଜାତା ଘରକୁ ପଳାଇଥିଲା। ଝିଅ ଏ ବିଷୟରେ ତାର ମା ବଡ ବାପାକୁ ଜଣାଇଥିଲେ। ଗତକାଲି ରାତିରେ ବଡ ବାପା ସହିତ ଫୋନରେ କଥା ହେଇଥିଲା। ତାର ନଣନ୍ଦ ସୁଜାତା ମହାପାତ୍ର ବାପ ଘର ଯିବା ପାଇଁ ବାରମ୍ବାର ତାଗିଦ କରି ମନା କରିଥିଲା। ତାର ହେମଲତାକୁ ଭୁଲ ମାଗିବାକୁ କହିଥିଲା। ମମତା ବାରମ୍ବାର ତାର ମା ବଡ ବାପାକୁ ଫୋନ କରି ତାକୁ ଗାଁ ନଉଳିପଡାକୁ ନେବା ପାଇଁ କହିଥିଲା। ତାର ବଡ ବାପା ମଧ୍ୟ ଆଜି 18/8/23 ତାରିଖ ଆସି ତାକୁ ନେବା ପାଇଁ ମନସ୍ଥ କରିଥିଲେ। ଆଜି ସକାଳ 8ଟା ସମୟରେ ସମୁଦ୍ର ଦିନାଶ ମହାପାତ୍ର ଫୋନ କରି ଜଣାଇଲେ ତମ ଝିଅ ମମତା ଆତ୍ମହତ୍ୟା କରିଛି।
Within 6 to 7 months of the marriage,
on the date of occurrence, the entire quarrel between the paneer was not given to the mother-in-law.
That is not.
That's the crux of the issue, my lord. And she is the married sister staying separately, having 2 years of male child and husband in custody, my lord. And charge sheet submitted 306, 304B and cause of death is for suicidal hanging. There was the previous application filed before charge sheet? Yes, my lord.
After 2 months of the marriage, the cruelty and demand of
No,
dowry started, my lord.
one thing, Mr. Mishra, here it says, you clearly that during course of inquiry as well as investigation, it came to light that so and so, so and so. এই প্রশ্নটা কো সাক্ষী কই না সে যে তাকে ফোন কলে যে তুই যদি তো বাপা
Yes,
ঘরକୁ
that is elaborately he has read, my lord.
ନା ଚାଷୀର ସେ କଥାଟା ଅଛି ସେ ଯୋଉ
ଏବେ।
ପନିର କଥା ତୁ ତୋର ବାପ ଘରକୁ କେମିତି ଯିବୁ ମୁଁ ଦେଖିବି ମୋ ମା କୁ ଗୋଡ ଧରି ଭୁଲ ମାଗ
Yes, yes.
ସେଟା ଅଛି
ସେଟା ଅଛି, yes, he has read, my lord.
ସେଟା 161 ଅଛି କିନ୍ତୁ ମା କୁ ଯୋଉ ଭୁଲ ମାଗିଲାନି that will not amount to instigation amount no କହୁଛି ତୁ ଯାଇ ମରିଯା ବୋଲି କହିଲେ ବି ଯଦି ଜଣେ ସୁଇସାଇଡ୍ କରୁଛି ବି that is also not
Why,
held to
my
be
lord, that 6 to 7 months of the marriage,
That's true,
why a
that's
lady
true.
should commit
498A
suicide?
may be there 498A will be
304B is also there, my lord.
no you
After
said
2 months,
304
all the father, mother and everybody says regarding the demand of dowry and torture.
in the
my lord.
161 statement there is no
304B
allegation of
is
demand of
also
dowry
there.
and the data on 15/8/23 my lord the dispute arose in the family my lord only because of that my lord that issue that ମୋ ମା କୁ ଭୁଲ ମା କୁ ବୋଲି then my lord all right the petitioner's earlier application for seeking anticipatory bail was rejected by this court as per order passed at ABL appeal number 9452 of 2023. The present application has been filed seeking renewing the prayer for anticipatory bail on the ground that charge sheet has been submitted in the meantime, wherein the case has turned to section 304B and 306 IPC along with other allied offenses. Stop. The petitioner is petitioner is the sister-in-law, married sister-in-law of the deceased, who allegedly committed suicide because of the physical and mental torture meted out to her by her husband and other in-laws, including the petitioner. Stop. Insofar as the role of the petitioner is concerned, insofar as the specific role of the petitioner is concerned, the same is mentioned in the charge sheet to the effect that on the date of occurrence, she had abused the deceased over phone and demanded that she fall at the feet of her mother-in-law and apologize. Stop. It is submitted by learned counsel for the petitioner that this by itself would not amount to instigation so as to constitute the offense of abetment to suicide. More so when there is no acceptable evidence regarding the physical or mental torture meted out by the petitioner to the deceased in connection with the demand for dowry. Para. Learned State Council has opposed the prayer for bail by submitting that the death of the deceased occurred shortly after marriage and otherwise than under normal circumstances. In view of the materials unearthed during investigation, the complicity of the petitioner is clearly evident. More so because of the presumption attached to the offense under section 304B. Para. Having perused the FIR from the charge sheet and other materials available in the case diary, this court is of the view that the only allegation only specific allegation against the petitioner is that she had abused the deceased over phone shortly prior to the occurrence. Even the nature of such abuse, prima facie, does not suggest, does not make out a case of investigation. Stop. Case of, sorry, instigation. Hala. Taking into consideration all these facts, this court is inclined to take a lenient view. Stop. However, this court does not deem it proper to release, to direct. This court does not deem it proper to grant anticipatory bail to the petitioner. But to direct her to surrender before the court below within 2 weeks from today, and to move for bail, and to move for regular bail. In such event, she shall be released on bail on such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. 1, she shall personally appear before the trial court on each date of posting of the case, and no representation through counsel shall be allowed under any circumstances. Yes.
May I please your lordship, item 50. My lord,
ରଖା ହିଁ ନେଇକେ ଟିକେ ଆଜ୍ଞା ରୁହନ୍ତୁ ମଣିଷ ଟିକେ ପାଣି ପିଇବେ ତାପରେ ଯାହା କରିବ।
my lord.
Yes.
May I please your lordship? This is an anticipatory bail, my lord. Case under section 379, 411, 120p and 34 of IPC. Allegation against the petitioner that while police patrolling party conducted raid, they found that a truck was being loaded with certain amount of coal, Your Honor, and subsequently that truck driver was asked for the document and he could not produce. And he stated that the truck was being loaded with the help of a JCB machine, and thereafter a JCB machine was seized, Your Honor. The present petitioner is the owner of the JCB machine.
Similar owner of the vehicle as
All right, similar order. Same order, in fact.
Please, Your Lordship. I am appearing on behalf of the case, Your Lordship. Alleged offence is under section 307, 323, 324, 506 and 149, and other alleged offence of IPC, Lordship.
same footing, my lord.
Same
As
footing and
the petitioners were earlier granted 4 to 5.
Granted Lipun Paikrai, alias Bapuni Paikrai and others.
Yes.
Specific allegation against.
Same order. Taka.
So item number 8.
Where of the petitioner there? Lordship, they to discuss the applicable interest of the financial assistance of which is 50 lakh, which she already received, Your Lordship. She died in 2020, and thereafter she tried to get the financial assistance which was not provided to her. Then she filed an the rate application before the Honorable Court, where he was declared as COVID warrior, and still they have not listened to the petitioner. She filed 2 contempts. And thereafter, they have disbursed rupees 50 lakhs as financial assistance, but without any interest after 4 years of span of time. And another thing, Your Lordship, the family assistant also she is not given till date. And Your Lordship, kindly have a glance to page 20, Your Lordship.
This is a money claim, sir.
Paragraph 5, Your Lordship.
Yes.
He has filed a representation.
But this is a money claim. Already those representations have been disposed of. 50 lakhs being a COVID warrior.
Yes, Your Lord. But without interest after 4 years, sir. That is. And financial.
And who are you? You are the sister.
I am the legal heir of the deceased.
All right. The petitioner claiming to be the legal heir of one Ratnaprabha Sodangi has filed this application seeking direction to the authorities to disburse the applicable interest. Court अच्छी से interest पाई बोली?
ସେମାନେ ଡେରି କରୁଛନ୍ତି ଡିଲେ କଲେ 4 ବର୍ଷ ପରେ ଦେଲେ ଆମେ କେସ୍ କରିକି
No. This will not be maintainable. This is a purely money claim. No, it has not been determined. It has not been determined. If you show, no, Mr. Roy, if you can show me that for delayed payment, he is entitled to interest. This is a ex gratia payment. This 50 lakhs towards given to the COVID warriors. Ex gratia payment. ताको पे भी तब interest मिलेगा.
filing writ
ये लोग
contempt application
No. See, writ application, I will not pass any comments with regard to the previous reader. I will not entertain this. No. You may seek withdrawal with liberty to pursue your representation submitted before the authority. That's all.
They have admitted. Kindly, your lordship. Page 20, paragraph 5, your lordship. Whereas perusal of the official documents reveals that the collector Khurda by order dated sanctioned financial assistance with 50 lakhs only in favor of Ajit Kumar Sodangi being NOK and authorized legal of Ratnaprabha Sodangi. The aforesaid sanction amount already credited in the bank account of the petitioner. Further, the collector Khurda by order dated 1878 dated 24/5/23 has also sanctioned COVID-19 warrior family assistance for payment of rupees 7,500 per month till she reaches 60 had she survived. It has already sanctioned, but that is not also disbursed.
Interest has not been sanctioned. Unless it is crystallized into a right, how can a writ court entertain a money claim?
At least in the family assistance, till date they have not given.
No.
To get the family
If you are filing, you may seek withdrawal with liberty to file a representation. With liberty to. So you say take liberty to pursue your representation. How about it? It's a maintainable way केमती हबो?
फैमिली असिस्टेंट तो दबा कथा सेटा दोना मंथली असिस्टेंट जोटा सेटा 7,500 लका मर्यादा उठा चेंज दबा कथा 60 वर्ष बाजे सेटा तो
ये लिखा पर collector Khurda has also sanctioned family assistance for payment of rupees 7,000. That I can consider. That direction can be issued.
That much.
Yes.
I'm good.
कौन लिख ले? The petitioner's sister, no?
Sister.
नहीं जरा काटूं. The case of the petitioner, briefly stated, is that his sister, who was working as Anganwadi worker of Somnathpur Anganwadi Center in Khurda district, died on 29/8/2020, being infected by the COVID-19 virus while in active line of duty. Stop. She was thus declared a COVID warrior, and accordingly, as per government norms, a financial assistance worth rupees 50 lakhs was paid to the petitioner, who is her brother and legal heir. Stop. It is his grievance, it is the petitioner's further grievance that despite sanction of COVID warrior family assistance to the tune of rupees 7,500 per month, the same has not been disbursed in his favor as yet. Stop. Learned counsel for the petitioner refers to order dated 9/7/2024 passed by the DSWO Khurda in this regard. Stop. This court finds that there is a clear mention that the collector Khurda, by order number 1878/SW dated 24/5/2023, has sanctioned COVID-19 warrior family assistance for payment of rupees 7,500 per month till the age of 60 years, had the deceased warrior survived.
Has to 10,000.
ଯାହା ହେଇଛି ନା ଅତ୍ୟଧିକ ଲୋଭ ନା ସେ କ୍ଲାଏଣ୍ଟର ମୁଁ ଆପଣଙ୍କ କଥା କଣ କହୁଛି ଆମେ talking to you. Such being the factual scenario, the writ application is disposed of, directing DSWO
collector.
Collector has already sanctioned it. Disburse ki kariye, DSW kariye.
PSW collector to 25 टा collector ही देते हैं
Directing the collector Khurda to disburse the family assistance already sanctioned in favor of the petitioner without any further delay. And in any case, not later than 1 month from today. ହେଲା
ଏଇଟା ଉପରେ ଇଣ୍ଟରେଷ୍ଟ କହିଲେ ଏଇଟା 4 ବର୍ଷ ହେଲା ଦେଇନାହାନ୍ତି
ମୁଁ ଜାଣିନି ଆଜ୍ଞା ମୁଁ ଯେତିକି ଲିମିଟେଡ୍ ପ୍ରାକ୍ଟିସ କରିଛି ଏଇ କୋର୍ଟ ମୁଁ ଜାଣିଛି ଯେ ମନି କ୍ଲେମ୍ unless it is crystallized into a right and if that right has been violated, yes, that will, in that cases one can consider. ଆଉ ଆପଣ ଡେରି କଲେ ବୋଲି ଆପଣଙ୍କର ଇଣ୍ଟରେଷ୍ଟ ଦରକାର ବୋଲି ଆପଣ ଆସିବେ ରିଟ୍ କୋର୍ଟକୁ
ପ୍ରାକ୍ଟିକାଲ ସେମାନେ ଆସୁଛନ୍ତି ଜଗତସିଂହପୁରରୁ ଗୋଟେ ଦିନ ଆସିକି ଏଇଠି ବୁଝିକି ଯାଉଛନ୍ତି ସେ କିଛି କରୁନାହାନ୍ତି ଏମିତି ଗଡି ଗଡିକା
କରିବେ ସେ ସରକାରୀ କାମରେ ସେୟା ହବ
ମସିଆ ହେଇଗଲା
କାନ୍ଦୁଥା ବାନ୍ଧୁଥା ଯେତିକି ମିଳୁଛି ଢେର ପାଇଲେଟ୍ ଠିକ ଅଛି
ଗ୍ରେଟ୍
So right now 10.
My lord, your lordship was pleased to direct the state council to produce the instruction. How many posts are lying vacant in the district of Puri? That Shiksha Sahayak matter, although she was selected to be posted at Bhadrak, but there was no post at Bhadrak.
You produced a letter dated 22/7/2024 of the CRCC.
Right now also I am having another letter at PI that is from Astaranga block. 11 posts of arts from class 1 to 5th are lying vacant. Class science, class 1 to 5, 18 posts.
Yes, what do you say?
This is at PI.
My lord, one information was obtained on the RTI. And when we submitted the information and there was a disparity, your lordship wanted that I should submit an instruction to that effect. So accordingly, on 30th July 2024, I submitted that instruction, my lord, clarifying that particular position.
This is 23/8/2024. Right now,
Another information has been.
No, 24/7 पर तो list है. It has not been. मेरे list है जी already date है जी 7/8 रही जी और 14/8 रही जी.
ना ମୁଁ ପାଇଲି 30/7 ର କପିଟା ମୁଁ ଦେଇଥିଲି last time.
30/7 ର ପାଇଛି ନା ଏଇଟା ଆସିନି ଦିଅନ୍ତୁ.
ସେଇଟା ବି
ଆପଣ 22/7 ର ଗୋଟେ କପି ଦେଇଥିଲେ. 22/7 ର ଯୋଉଟା which was contrary to what Miss Jana had said.
Lordship में
इते कौन अछि
एइते हमको क्लारिफिकेशन जोटा मागिले जे तांको आरटीआई रो इंफॉर्मेशन हमर जो इंफॉर्मेशन ता ओटा नॉट मैचिंग विथ ईच अदर
No, I will sort it out. You sort it out and give a concrete view. I'll call it tomorrow. But you sit with Mrs. Jana, find out what she has brought.
Yes.
Obtain instructions telephonically. Prepare a chart and give it to the court. That's all.
Yes. Then my lord, this matter will be taken up next week.
All right, next week then.
We'll sit together and we'll matter out a copy.
Heard further arguments in part. List this matter next week.
Yes.
Please do that. Please do that exercise. Both of you, it will be better if you sit down and so that the reconciliation can take place.
Yes.
And if necessary, you can obtain telephonic instructions from the person concerned. That's all.
I'll get it.
Yes.
So right now 11.
Last occasion, lordship heard this matter. Only the petitioners was denied on the ground of the residential certificate. He originally, that is belongs to Simulia, but he got married Bhadrak. That is Chandramani Jana's case, that a part has been already gone, my lord. That's why she was not considered, and she had filed the writ petition in 2007, and thereafter, my lord, the application was pending. In 2018, again the authority government sent a letter to the collector to consider the case, my lord. And due to the non-disposal of the case, he again came before lordship. This honorable court directed to dispose of the repension married. The repension are disposed of on the saying that in the matter of 2007, and your case can consider because the panel list expired after 1 year. But only this petitioner's grievance has been subsisting since 2007, my lord. And his case and the authority also directed the collector to consider the case, but he did not consider.
Where is that order? Where is that order? Impugned order.
Impugned order under Annexure 5, my lord, under Annexure 5, your lordship, that is page page 15, my lord, Annexure. No, it's page 15, page 16, my lord. Page 16, commencing from 60.
He says that there is no vacancy. It has been concluded in 2007. That is what he said.
That's right. But this is Supreme Court also there is a case also I have cited in the rejoinder in the case of Shaktipada Mahapatra. And he came before this honorable court. Single bench rejected. And thereafter came to the division bench. Division bench rejected. But Supreme Court allowed because he is entitled to get even if in 2007, my lord. And the direct I have cited and I have given the
What is your stand?
Our stand is that, my lord, after the first round of litigation in the year 2007, when there was a direction to the collector to take a decision, in the year 2009, my lord, a decision was taken. And that was never been challenged by the petitioner. Once again, my lord, in the year 2000, after a period of 11 years, without challenging the same, she approached before this honorable court. And in the present case also, my lord, that has not been challenged. And second thing, my lord, if your lordship will come to that particular rejection, there the collector has specifically stated on two accounts, my lord, the petitioner's candidature has been rejected. One is on the ground of cancellation of the residence certificate. It is not on the ground of that, my lord, a person does not belong to that particular residence. The residence certificate has been cancelled. And the second thing, my lord, the SCBC certificate, the caste certificate has also been cancelled. And her claim to be a candidate in the merit position at serial number 3 in the first list on the basis that she is belonging to SCBC category. The caste certificate has been cancelled. And that is the document. He has never whispered anything in the writ petition. And we have filed it, annexing the same in our counter. And he has filed a rejoinder and he has also not disputed this. So, Chandramani Jana case is not squarely applicable to this particular case, madam. They are only the ground of residence where the block as a unit was changed to the district as a unit. And on the ground of not residing in that particular block, a person's candidature was rejected. So that was, when that was issued through a corrigendum, that corrigendum was quashed. But here in this case, the two certificates that has been cancelled, and those cancellation of certificate has never been challenged. And one of the certificate that is most important for determining the merit in the same category, that is SCB certificate, the caste certificate.
Let us hear this finally. Yeah, we'll hear this finally. Finally, here can you conclude?
But my lord, my learned friend is submitting that the SCBC certificate, that is not a case, my lord. Your lordship, if you will go through, my lord, that is the order, then reflect there is no SCB certificate case is here, my lord. Your lordship, may I permit you to read these things?
No, that is true. That is true.
Yes, but only residential, because of the residential certificate, because there is residential certificate is waived out. That is under Chandramani Jana's case. Throughout in the country, in the any part of the country, a person will reside. Then he can submit the candidature for the engagement, and because he must be an Indian citizen, but only because of he has a mother tongue in India, because he passed the matriculation certificate here. That is the Chandramani Jana's case. Chandramani Jana's case.
No. As he has rightly pointed out, Mr. Patnaik, the ground of rejection in the impugned order is something else.
And so C/4 may be perused, madam.
No, I will. But before that, which he has challenged, which he has impugned.
Yes.
Here it says that because of expiry of the process of engagement in 2007, and there are no vacancies, so he cannot be considered.
My lord, he concentrated only on the ground of residence in the subsequent repentation. But in the previous repentation, when it is considered...
So you mean to say that will operate as a res judicata?
My lord, Annex C/4, page number 19, a specific observation is there. Page number 20. The decision of the collector, which has not been challenged.
Your lordship come to the annex of that is 3.
Page number 20, my lord, of my counter. On perusal of the selection list.
All right, we'll do one thing. I'll keep it next week. I'll keep it to next week. Prepare finally. And you may also respond to what they have said in their counter, because this order also stares at you. This order of the collector, which you have not challenged previously.
And even after filing of the counter, my lord, he has filed a rejoinder and he has not. responded.
Annex of 3, collector has also, your lordship, see, the government has written a letter to the collector. It is 16/8/2018.
No, that's true. That's
What
true.
in the 18, your lordship, see, that is page 14. How did he write a letter to consider his case? When the government has written a letter enclosing a.
That we will see. That we will see.
Yes.
So whether a question of waiver can be applied or not is to be seen. Whether that objection, initial objection, whether it has been waived out, because in the subsequent order, the collector doesn't say anything about that residence thing. He doesn't say anything.
No.
Or the cancellation of the certificate. rather.
Caste certificate.
Cancellation of the caste certificate. It doesn't say anything. It doesn't whisper a word.
In the first case, my lord, in the first round of rejection, he told about both the rejection of both the cancellation of both the certificates. But since the petitioner concentrated on the residence only, in the second representation and thereafter he approved for this honorable court, relying upon the Chandramani Jana's case.
No, the collector should have.
Yes, sir.
The collector should have.
But
the fact remains that the order is still there.
If it is a fact, my lord, my submission, my lord, if it is a fact that the caste certificate has been cancelled, whether the petitioner is in a position to avail the benefit of out of the caste certificate and to get the position in the merit list on account of as a SCBC candidate, man. That is what.
What about as a UR candidate? As a UR candidate?
His case has not been under the UR SCBC category, my lord, you are not considered.
नहीं दोनों तो SCBC caste certificate को बाहर कर दिया जी वो. ताले he can be a UR candidate. Whether in such a circumstances can he be considered or not? Even a ST candidate can be treated as a UR candidate. You know that in the merit list. So I would like to know that. Even assuming that his caste certificate was cancelled, that doesn't throw him out of the ring entirely, because he still continues as a UR candidate.
Whether he is within the merit position or
That
not.
you have to find out. That
Yes.
you have to find out.
Merit position, 3 position.
That you have to find out. So notwithstanding cancellation of the caste certificate, if his candidature can be considered, then this court will always consider it, provided he has secured the adequate number of marks. Yes. If he has not secured the marks, end of the matter. Yes. But further arguments apart, please this matter next week. Next week it will be completed.
Present जो order term challenge कर क्षेत्र की they have not reflected anything.
Not how. Doesn't matter. Doesn't matter. Even if even notwithstanding cancellation of the certificate, it still can be done. Yes. All right. कितना पास हो रहा है? छोटा.
Respondent, my lord, 15 days back. So I'm humbly pray my associate's name and my name will be deleted, my lord.
55.
55, my lord.
Who is for the appellant? So wait, let it reach them. Let it reach. Yes.
45 can take no Friday.
Pass over. Pass over will mत देखो.
Item number 12.
Dispose of.
Item number 14.
dispose of.
Item number 25.
Item 25, may I please see? I say I am appearing on behalf of Mr. P.K. Rai Milsi. The last occasion Milsi notice returned unserved from the sole opposite parties with a postal tracking report Milsi, long absent.
You take fresh notice.
Milsi, fresh notice.
Issue fresh notice to the opposite party
Opposite party number
by speed post. Fixing a short returnable date. The requisites be filed within 3 working days. Place this matter on 23rd October.
interim order is there.
Interim order to continue.
Hon'Ble.
Item number 40.
Item 40 may be taken up on Friday.
Place this matter on Friday as prayed for.
Item number 47.
Item 41 also.
41 so 41 कौन है इतना? Modification has been allowed. Yes. 47.
May I please? Since about 5 June 2021, more than 3 years. Plus the co-accused person released on bail, your lordship, that reflect on page 50. That was in the co-accused person. The order.
He is a local person.
Because
The person who has been released is a local person.
here, Lord, I'm in custody more than 3 years. And lordship, plus the trial has not been progressed.
The court below is directed to furnish to forward the report regarding status of the case. Please this matter on
25th September.
25th September.
Spread.
Item number 48.
Tomorrow.
Tomorrow is spread for. Shatik, weekly list of honor. Patata.
List item number 4.
Item 4, I was supposed to proceed with the hearing in the sense in the orders for permission and for condonation of delay.
Yes.
But while preparing, I found that there is a gross omission in the application filed for condonation of delay. The period consumed for for getting the certified copy, I have not explained. That is necessary for your lordship's consideration because there has been a long delay.
Amend your application if you want.
Pardon?
You may amend your application.
And I'll just clarify one thing,
No.
Your Lordship, this has been heard, Your Lordship knows, on 3-4 occasions. If there is copy period that's available on record, that also, Your Lordship will always take note of. Now, Your Lordship sees in this case, for this limitation matter, the government has taken at least 5-6 times. If Your Lordship
That is not.
and if this copy period has not been mentioned in the limitation petition, that Your Lordship can see it from the record that's there.
He doesn't ask. So if he accepts it,
This
he
is
will do
what's
it.
going on.
One chance may be given.
But
I will have to get the.
But this is just going on, my lord. I don't
No,
know
it
for
will
what
not
reason.
go on.
And I'll show to your lordship, the suit, the claim for appeal is beyond the scope of the suit. I have not claimed anything against the state.
Necessary.
It's against OSFC.
Not necessary. It is state
State
property.
can go
It has
elsewhere.
been subjected to auction by the
State
OSFC.
doesn't know the forum, that is the difficulty. So my decree is not against the state.
Wait.
May not.
He admits that copy period thing.
Yes.
So that can always be taken note of by the court. Well, if you are willing to argue on that, well and good.
No, that would be necessary in the sense the consumption of time so far will be better explained if I apply for if I incorporate those portions when the application was made and how much of time has been consumed in preparing the certified copy.
All right then.
A copy period, I'll just clarify. Why, my lord, that has not been shown? when a limitation is shown, your lordship, it is always excluding the copy period. I just wonder how this can help.
No, no, no. Because of
Yes,
the long.
when an appeal limitation is calculated, the copy period is always excluded from the limitation period.
Who says no? Here it is necessary that
I don't want to join issues in a piecemeal manner, but the issue is, my lord, for a limitation matter where objection has been put in and argument has been made, decisions were cited, your lordship was about to close it, adjournments are sought for again and again, my lord, for improving upon the case. After the case is argued and everything is virtually concluded, the state wants to again improve upon it, whether it's some laxity. Also, one Supreme Court decision where the Honorable Appellate Court has been pleased to say that despite giving opportunity and filing of affidavits also, the case doesn't improve and that has been rejected.
No, here it's a question of not improving. It is a question of that, as you have yourself said, that it is a question of exclusion of time on the account of.
My lord, if
So-
that is the submission, your lordship may kindly see the record. That period has been excluded or not? That period has to be excluded, my lord.
No, here it is a certified copy period nil will লেখা আছে।
Nil, because সেটা সে country beyond limitation, সেটা copy period can be excluded হবে।
No, we do not know. We do not know. How do I know the facts? I can grant you 2-3 days if you want
2-3
to.
days may not be sufficient.
कौन हो कितना हो?
2 weeks minimum.
No, 2 weeks.
Because I will have to inform
No,
them.
this has been heard. No. This has, as he has rightly pointed out, this has been heard in full, Mr. Das. At this stage, I cannot grant you further time. I cannot grant you further.
That was a 2 PM matter. I missed it for, but I'm saying that I missed for this case. I'm always in a state of uncertainty whether this case will be at all taken up or
No,
not.
that's a.
Every time the state takes time. And had I been told, my lord, I would have conducted that case. I missed that. That was posted from pre-launch to
All right.
that PM.
How can I assure you?
There.
No,
Can I
wait.
assure you that?
I can grant you time.
Give
I
me
can grant.
assurance.
On 13th, if your lordship please.
If you had a plan to take adjournment, I should have been intimated in advance.
Just a moment, Mr. Mishra. I can grant you time for 1 week. That's all.
Sir.
1 week time. IA 425 of 2020 লেখন্তু Sri A.R. Das Learned AGA submits that he needs to incorporate certain additional facts in the petition condoning the petition for condonation of delay in as much as the time required to be excluded for the time required to be excluded on account of application on account of application for certified copy has not been mentioned in the petition. Stop. He therefore wants to amend the application by filing appropriate application. Sri
File additional affidavit, your lordship.
file additional affidavit. Sri Mishra Learned Counsel appearing for the respondent. This seriously opposes the prayer for adjournment on the ground that the matter has already been heard extensively and the state cannot be allowed to improve upon its original position. Stop. After hearing learned counsel for the parties, this court feels that ends of justice would be better served if one opportunity is granted to the state to file additional affidavit as requested. Stop. List this matter next week.
No place.
It is made clear that no further adjournment shall be granted under any circumstances.
Let my non-senior also give a copy in advance so that I can assist your lordship.
Yes. You prepare it and file what is called date.
I will have to get the instruction from them because I don't.
Over telephone, get it. I will not grant further time. Yes.
May I pray for 13th?
It will be in the weekly list. It will be taken up on 13th if you want. 12th or 13th. 1 or 2 days doesn't make any difference. Yes. Week commencing 9th ratio. List it or Yes.
Item number 5.
লেখা এই যে খাতা কাগজ ওটা দিয়ে
First, I'll take a lordship to substantial question number 3. That your lordship is framed.
5-8 অর্ডারটা नहीं স্ক্যানিং
whether the issue number 3 as framed by the land trial court to the effect whether the suit is barred by limitation is to be recasted as to whether the suit is prematurely filed. On this, my submission is, my lord.
Yes.
Generally, issue is framed on the pleadings of the parties. Facts stated in the plan and what are denied on facts and law. On
Yes.
this, your lordship may kindly see order 14 rule 1. So, present case, my lord, there is no averment in the written statement that the suit is premature. No averment. So, accordingly, the court has framed an issue with regard to limitation, and that is affirmatively answered. At the second, and confirmed by the first appellate court. At the second appellate stage, this issue under no circumstances can be framed by framing a substantial question of law which lead to giving opportunity to parties to lead evidence, rebuttal evidence, which is not permissible under law. And my submission is whether the suit is premature or not, it is a mixed question of fact and law. It cannot be said a pure question of law, so that it can be taken up in second appeal as a substantial question of law.
Yes.
Then this is my submission so far, whether it is premature or not. Then I will take your lordship, before taking your lordship to other points, I will take your lordship to the decision I have submitted,
Just say.
flag D. Your lordship may kindly see flag D. – 2024 volume 2 current civil cases 198 Supreme Court.
Yes.
I have already submitted with lordship paragraph 17 that on death of a partner, if there is no other contract, then it dissolved. And further, if a partnership consisting of 2 persons, on death of one, automatically, even if there is a contract, it goes. Now I will take your lordship to paragraph 19. After death of the partner and dissolve of the partnership, what will be the fate? Paragraph 19, your lordship may kindly see.
Yes.
A prevent plea was raised by the land council for the respondent that the farm continued to exist even after death of Sri M. Balraj Reddy and the business activities were continued by the firm, even if it is assumed for the sake of argument that the partners were carrying on business activities after the death of Sri M. Balraj Reddy, there cannot be any doubt that the firm stood dissolved automatically in the year 1984, as mentioned under section 42C of the Act, unless and until there was a contract between the remaining partners of the firm to the contrary. Here there is no remaining partner. Then, important matter, there is of course no such averment by the respondents. Then, the business activities, even if carried on by the remaining partners of the firm after the death of Sri M. Balraj Reddy, would be deemed to be carried in their individual capacity in the circumstances noted above. Here, my lord, undisputedly it was a two-man partnership firm. So, after death, automatically it would be a proprietorship concern. Much thereafter, other 2 persons have been come in, or partnership they have constituted. That will be a new partnership firm, not the continuation thereof in view of this law. So, even if they carried on business by stepping into the shoes of the earlier partnership firm,
yes,
a third party cannot be bound by that. Here the present plaintiff.
Yes.
That is my case. Now, your lordship on the last occasion has raised me to submit, and accordingly, your lordship has posed a question to me whether the suit is premature or not. So far, the substantial question of law is concerned. My lord, here, if there is a breach of the contract stated in the development agreement, or anything thereafter, or the farm has dissolved, the power of attorney has dissolved, then by aid of section 34 of specific relief, I have to file the suit because it registered one. Now question is whether your submission has been made before Lordship that the period will come expire in 2005. The contract period will expire in 2005, 25. But my submission is that will not apply to me because my submission is there is no partnership firm, there is no power of attorney. So the development agreement in between me and the erstwhile partnership firm has nothing to do with the present firm. Furthermore, on this count, I will take your Lordship. If the breach, suppose my Lord, a contract is executed, there is time limit is there. 3 years, suppose. But prior to expiry of 3 years, there is violation. Whether the party agreed will wait till completion of 3 years, then file this suit. Thereafter, he will get 3 years. Or he will file immediately after the breach. That is the law. My submission is the moment the breach is committed, party agreement can file the suit immediately without waiting till the expiry period of the limitation, age between the contract. Now on this, again, 2024 6 scale 450. The Lordship may kindly straightway come to paragraph 16, my lord. Paragraph 16. It was a suit for specific purpose. The law is stated.
Yes.
Right? 16 again. In such case, this court held that every suit for passive permanence need not be decreed merely because it is filed within the period of limitation by ignoring time limits stipulated in the agreement. Then the courts will also frown upon suits which are not filed immediately after the breach of the refusal. The fact of limitation is 3 years does not mean that a purchaser can wait for 1 or 2 years to file the suit and obtain a specific performance. So, taking into consideration this principle of law, my submission, when the breach occurred and there is no partnership firm and GPH, so I have no way out than to file the suit immediately. Accordingly, I have filed the suit. So my suit filed is not premature at all.
But there was, you don't say there was any breach of agreement.
Yes, it is there. Yes, I will take. To that aspect, I will take your Lordship. After this is the law, then I will take your Lordship how the breach is committed. Then, my Lord, your Lordship, regarding the breach, your Lordship may kindly turn to the plaint. Paragraph 8. Plaint paragraph 8. Page 5 bottom, my Lord.
Yes. Paragraph
8 of the plaint.
Yes.
Paragraph page 5 bottom, my Lord.
Yes.
Last 2 lines. Besides that, it is learned that without obtaining ORERA registration certificate, the defendant firm are collecting amount from the intending purchasers by advertising the project, which is complete violation of the road regulation prescribed by ORERA. All the acts done by the defendants amount to implied refusal to perform the promise under the agreements and entailing the plaintiff who signed the contract. Then other things, I have not other things. Then at this moment, your Lordship may kindly turn to paragraph 15 of the written statement. Paragraph 15. Just evasive denial, which is deemed to be admitted. That the averments made in paragraph 15, my Lord.
Yes.
That the averments made in paragraph 8 is absolutely false and baseless, designed for the purpose of the case, hence denied. There is nothing to shock after receipt of the letter of the defendant, for rather he will happy that the defendant firm trying to pay off the share of the owner even before the contractual date. So to paragraph 8, my lord, this is evasive denial. Evasive denial is deemed to be admitted. No denial, it is to be admitted. On that line, it will also. I also come with two Supreme Court decisions, my lord.
That is statutorily.
My lord, order it rule 5. Order it rule 5. So when it is not denied, deemed to be admitted, I need not prove it. Furthermore, I will take at this moment, I will take your lordship to the development agreement, that is exhibit 8, exhibit A.
No, is it necessary?
Yes, my lord, yes. It is necessary, my lord. Clause 14 again. Page 6 again. Development agreement, clause 14. Even prior, why I am showing this lordship, even and prior to entering upon to the development agreement, they have collected money from the prospective buyer.
You are referring to exhibit?
Exhibit 8 again. Tankar 8. Original ta A.
Yes, yes.
Again, paragraph 14. Clause 14, sorry. Clause 14. Page 6. Page 6. Again, no table diagram.
Yes,
Table of 14 serial ko again kindly assume.
yes.
14. Prospective buyers, how much they have paid. Your lordship got it, my lord? Then your lordship may kindly see on that respect clause 23. Clause 23. That both the parties here to agree that second part of the builder cum developer is free to advertise the market for the proposed apartment, residential, commercial units in the said project as per the prescribed rules of Odisha Real Estate Regulatory Authority over the land and receive advance from the intending purchasers, execute agreements for the same, and such other things are there. So, advertisement, receiving advance or agreement will be as per the RERA Act. Now, your lordship may kindly see. Your lordship may kindly see it for this month, the RERA Act. Real Estate Regulatory Authority Act. Section 3.
Yes.
No promoter shall advertise, market, book sale, or offer for sale, or invite person to purchase in any manner any plot, apartment, building, as the case may be, in any real estate project or part of it in any planning area without registration of the real estate project with the Real Estate Regulatory Authority established under the Act. So, not only by the date of development agreement, but also thereafter, and to my submission, till the suit was filed and a status order was passed, the project was not registered on section 3. And your lordship kindly 6, section 4, the filing of application. And with this, your lordship kindly see rule 3.
What is it?
Rule 3.
Yes.
That prescribes the norms. So, my lord, here, my lord, for this, I have shown your lordship from clause 15 of the agreement, 14 of the agreement, that prospective buyers have paid. Unless and until it is registered, they cannot enter into an agreement also. Your lordship may kindly see, pro forma agreement is there. Agreement is also there. Your lordship may kindly see that.
I got the point.
My lord. The agreement is
So
so.
unless it is registered, according to you, they cannot advertise or they cannot enter into any agreement with any prospective buyer.
But they have. But they have done.
That is on record.
Yes. So it is a breach. So when breach occurs, I have to take steps immediately and I have filed this suit. Assuming that
Yes.
the partnership is continuing. Assuming, but not admitting. My argument is a twofold. If your lordship will accept my submission that there is no partnership firm, the GPA is terminated on death. So I need not wait till the further breach. And these breaches occur when the managing partner Mr. Patra was alleged prior to 14/12/2020, not thereafter. Even if assuming that it will continue, then this is my case, my lord. This is my case.
Yes.
Then your lordship may kindly see, I have taken your lordship to the paragraph 19 of that 2024 Supreme Court decision, individual capacity. For that purpose, your lordship will permit, I will show your lordship certain clause from the development agreement.
Yes.
Your lordship may kindly see first the development.
No, you want to say that regarding that breach?
No, breach, not breach. In the development agreement, there is nothing that after, if in any circumstances the partnership form is dissolved, it will continue. Rather, it is said that it will be inherited by the legal heirs. The lordship may kindly see first the cause title of the second party, last again.
कितने से exhibit?
Exhibit say 8 है. 8 by 8 don't understand. Second page रहा हम बेसी देखिए भी नहीं पढ़ेंगे. First from the top, my lord. Herein after called the builder cum developer the second party, which expression shall, unless excluded by or repugnant to the subject or context deemed to mean and include their legal heirs, successor partners, partners means surviving partners, administrator, etc. The lordship got it, my lord?
Yes, yes.
Then clause D again, देखो. Clause D, next page, sorry. Clause D, no, sorry, definition of partners.
Yes.
Page 3. Definitions again, say bottom, definition of bottom को. The builder cum developer.
You are reading from exhibit 8.
Again, exhibit 8.
Exhibit 8 to internal page कितने?
Internal page का मैं bottom आपको देखो जो 3. Exhibit 3 रा bottom.
Bottom is the builder cum developer.
Yes, yes. The builder cum developer shall include its legal heir, successor in interest and or assignees. So on this point, I am clear, my lord. Taking into consideration paragraph 19, my lord.
Yes.
Of that Supreme Court judgment.
Yes.
So there is no partnership firm in the eye of law. And the newly constituted partnership firm cannot claim that I will be bound down by their action. But as because I am residing abroad, I am an honest and prudent person. So I have offered that in my plan that I am ready and willing to return their money. Now I will take your lordship again. They have paid the amount, certain amount, but that is only for security. And furthermore, again I will take your lordship to that development agreement. In the development agreement, your lordship may kindly see clause 4, my lord.
Yes.
Clause 4 says that a separate supplementary agreement on the right to sell the apartments allotted in favor of the first part, the landowner, by the builder cum developer, the second part will be executed between the parties after obtaining the approval of the building plan by the Bhubaneswar Municipal Corporation BMC and registered by the Orissa Real Estate Regulatory Authority (ORERA). This is the definite clause. My lord, this is 7/8/2020. On the next day, the supplementary agreement, my lord, that is Exhibit B and Exhibit 9. The supplementary agreement has been executed, and in the supplementary agreement, nothing is that this clause has been taken away or deemed to be deleted. Nothing is there. Simply the supplementary agreement is that they will pay me 15 crores, including the security deposit, and I will abandon my share in the property. Nothing more. So when the main agreement exists, the supplementary, unless that is abrogated or amended, is a supplementary agreement is of no consequence. It is not an independent one. It is a supplementary one in addition to the first one. So my submission is, on this background, I have also taken that hurriedly they have taken the supplementary agreement contrary to the development agreement. This is a breach, my lord. Then, my lord, substantial question of law, either again substantial question of 2, 3 and 2, 3 gala again. Then substantial question 0.4, my lord. With regard to 55 of the Indian Contract Act, on short I will submit.
This is question number 4.
4, Roman 4, my lord.
Yes, yes.
With regard to section 55 of the Contract Act, here my only submission is that when there was no, I will reiterate, when there was no development, no power of attorney, partnership dissolved, so rightly the land trial court has held, attracting section 55, no illegality has been committed, and it is confirmed by both the courts below, trial court and the first appellate court, and it is not a substantial question of law at all. And by even if your lordship will answer the substantial question of law in their favor, then also they will not succeed in the suit, because my submission is, in law there is no partnership part, there is no GPA, nothing. Then Roman 5, my lord. So next substantial question of law. Here in this paragraph 5, my lord, your lordship may kindly the substantial question of law 5. Whether the findings of the land trial court under paragraph 13 of its judgment is liable to be set aside as the same are beyond pleadings and materials on record and based upon surmise and conjectures. The lordship may kindly see paragraph 13 of the trial court judgment. My lord, here, my lord, before taking a lordship, may not be necessary, my lord. My submission is that suppose the trial court has committed the mistake, so far this paragraph 13 is concerned, but that has been affirmed in the first appellate court. So the judgment of the trial court is merged with the first appellate court. So when the first appellate court has confirmed the order in an independent judgment, giving the detailed reasons, the finding of the trial court cannot be faulted with. In second appeal.
Yes.
My lord, in second appeal,
yes.
And had it been a reversing judgment, then I can understand, my lord. Suppose in the suit they would have succeeded, and first appeal is they have failed, then this point can be taken. But when it is a confirming judgment, there is a merger. So this point cannot be agitated in second appeal, my lord.
Yes.
So on all these points, my lord, my submission is there is no merit on the second appeal, and most of the substantial question of law are not question of substantial question of law, maybe question of law. So the second appeal may dismiss, but I have, my lord, if lordship will permit, I have filed 2 decisions. What is substantial question of law? What is error? But they
that is fairly well settled.
Sir, when will you reply? Friday?
On Tuesday. I will reply as well as I will submit my
Then he had also said that day on that he will argue on 10th. Heard further arguments in part. Lest this matter in the week commencing 9th September. With the understanding that it will be called out on 10th. Mark pass over automatically. Or you can ask anybody to just make a mention that it will be taken up on 10th. I have asked him to mark still then. Is any? सही तो हियरिंग टू कंटिन्यू तापर हम देखियो हम हियरिंग आरंभ ही करेंगे कल हियरिंग रे जिबा हियरिंग सारला परे पुनी पास ओवर को जिबा नहीं गोटा सेटा सेटा खाली पाठड पई हम रखथिलो ना हां
item number 40
इनो ताके सारदा गडे दबा The method is the same, excepting for those parted matters. We will once run through the list, then we will come back. Achi Friday, achi bhai. Item 40.
Alert may be taken up on Friday.
Friday.
Yes, ma'am.
All right, Friday. Pass over.
item 41
41.
Item 41 also.
41 also same.
Oh, let.
No, mane pass over. Pass over kali Friday will mark कर दी
item 42
You have taken consent of Mr. Das? All right, all right. Next week? For a week record. All right, as requested by Shri Maheshwar Mahathir, let this matter in the week commencing 17th September.
item 43
Your Lordship, kindly this matter be taken up on Friday, Your Lordship. I have informed the opposite counsel.
All right, Friday.
Okay.
item 44
Yes, Mr. Mishra. Who's opposing you? Mr. Tushar Mishra.
Well,
I think I have seen him today probably.
May I prayed for 17 because what has happened after the notice was issued my lord only on 12/3. Thereafter, I have not been able to.
All right, let's just matter in the week commencing 17th September.
I'll inform my friend also.
Please.
item 46
46. Your matter.
Friday. Password. I don't know. Password.
Item 40. Oh, yes, Mr. Somebody was mentioning in the morning.
Yes, my lord. I am 46.
No, 45. I am on 45. Oh, password. Okay, okay. 46.
For system calling.
Kona?
Shukrawar.
Kona, Shukrawar ସବୁ ରହିଲେ କେମିତି ଆମେ ହିୟରିଂ କରିବୁ ଆଜି କିଛି କରନ୍ତୁ ଆରାମ କରନ୍ତୁ ପାଠଡ଼ କରି ରଖିଦେବା ଗୋଟେ କୋଉ ୱିକ୍ କୁ ନା ବିଲକୁଲ ଆପଣ ଦେଖିନାହାନ୍ତି
ଏଟା ମୁଁ ଭାବିଲିନି ଇଆଡେ
yes all right Friday
50ଟା ଆଇଟମ ଦେଇକି ଭାବୁଛୁ ଆପଣ ଇଆଡେ ଆସିବେନି ବୋଲି
all right Friday ମାନେ ବେଳେ ବେଳେ ଆସିବ ଆସନ୍ତୁ ବେଳେ ବେଳେ ଖରାପ କୋଟ ହେଲେ ବି ବେଳେ ବେଳେ ଆସନ୍ତୁ
ମାନେ your lordship may not deprive us privilege.
I'll give a reply outside. Yes, item 47.
47
Tushar Mishra. Mr. Tushar Mishra.
46 is Passover.
Yes, Friday. Passover means Passover for the day. Item 47.
Looking at the energy of my friend, I am feeling very happy. I'll be always happy for my friends to.
Yes, 47. 48.
47 kindly taken up on Friday.
Passover. Friday, ଯେତିକି ହବ ହବ.
item 48
Yes, Mr. Guru, can we not take it up tomorrow? Tomorrow it can. Item 47, huh? Item 47 tomorrow.
Some matter also I had my lot, item 22 also.
No, 22 को मुझे जाइए मैं पहुँचा जाइए 48.
item 48
Okay.
Passover.
item 49
Item 49 can taken out tomorrow, my lord.
Tomorrow.
item 50
Passover. Huh? I would touch 51.
item 51
51 is your matter. Yes.
I cannot.
Then begin. If he doesn't, if he is not there, what can I do? The court cannot go without work. Let us begin.
Wait, please, your lordship. The defendants are appellant against the complaint.
Yes, let us see the substantial.
The genealogy.
Whether they, let me just go through the substantial question. Whether land traveler exceeded the direction of the appeals. Yes, you wanted to see, you wanted me to see the genealogy.
Yes, ma'am.
Where is it?
Memorandum of appeal, page 3. Page 4, answer.
Page 4, yes.
Satyanarayana had two wives. Satyavati is the first wife. Second wife is Ashtami. They are the defendants, that branch. And first wife's daughter Jagjasani is the plaintiff. Plaintiff filed a suit for declaration of right title interest and for discovery petition. The defendants filed their written statement claiming that the property was purchased by my husband and the children said our father. Because you are a government servant, that is why he could not purchase any name. It was a benami in the name of the property. The suit was decreed. It went up in appeal. We went up in appeal. In the appeal, my lords, your lordship, come to the absolute judgment. The judgment of.
Mr. Kuntia, what does this second wife have? What right does she have now? Was that marriage
Before 1956.
All right. I just need one fact. No, please clarify one fact. Whether this person, Satyanarayana Sai, married during subsistence of his previous marriage.
Because there was no son.
I'm fully conscious that I am dealing with her children. At best, they may be termed as, that.
Oh, yes.
Yes. I don't want to use that word because Supreme Court has said that you can't use that word now. But I'm referring to that word.
Yes.
They have a right.
They have the right.
I'm just asking about this Ashtami. You say that but according to them, the property, you say that the property was purchased Benami in the name of the first wife. Why?
It was the government servant.
So he could not have purchased.
He could not have permission, etc. He was working in the excise.
All right. Then,
that was the order before him.
Okay.
What happened, my lords, in the first appellate books? First appellate book, just as I am referring to the ordering position for LCR. BP Datta, Mr. Datta.
Yeah, judgment achi. I have the judgment.
Then impugn judgment as second. It a remand is fair as well. That's why.
So you want me to see the judgment dated?
This is dated 16/3/2000. I'm sorry. 3/11. Date of 15/11/2014.
15/11/2014.
Again. Remand is asset.
So that must be in the LCR, isn't it?
Again.
You are right. So we must see the LCR.
LCR plus
LCR, yes, Mr. BP Datta, Birija Prasanna Datta.
Yes, my lords.
The elder brother of the other Datta, Silu Datta.
What's my associate or some Mr. Basuga office rate?
Mr. Das, slowly. My mind is being distracted towards you and Mr. Guru.
Sorry.
I am not that expert in civil matters like you, sir.
Expert.
No. That is because court is expert of experts. Otherwise, I think so far as civil matters are concerned. No, sir, I need concentration to.
Sir, very necessary.
Yes.
Page 7.
Because I don't read my brief beforehand, I open it for the first time here. So I have to hear very focused in a focused manner.
What we know is that Mr. Chakla used to do it.
Somehow it is my habit. I don't.
Mr. Chakla, what was in December on your boy read the continuous court. Now, continue court.
And I'm going to brief Jayani.
Jayani. Follow. Open mind ras. Sir,
so this was
again page 17 put together.
Page 17.
Again.
Of the
Mr. Datta's.
I mean internal page 17.
Internal page 17.
Yes, the order. Yes.
Last question to 17 now.
it is a fit case to remind back to the lower court for self-adjudication by framing an issue on the Benami transaction as discussed above, giving opportunity to parties to adduce to evidence on that scope and nothing more.
No, on that aspect alone.
Alone.
Only.
So they come to order that. That is interesting. That the approach is reminding the suit bearing CS number 95 2010 to the London lower court for adjudication of the dispute between the parties appraised by framing issues. That is put issue by framing issues on the aforesaid aspect related to alleged Benami transaction and giving opportunity to both the parties to evidence on that aspect only. And then the lower court shall give his finding on the basis of entire evidence on the issues appraised adjudicated matter. So it is a question is whether it is a closed remand or an open remand.
Yeah, very confusing.
That is the crux.
Alleged Benami transaction and giving up. So he says that only that relating to that Benami transaction. Now he says that the basis of the entire evidence on all the issues are fresh and adjudicate. We will take it as an open remand. You cannot. How can you? Prima facie it appears to be an open remand.
issue को से कल only Benami. तापर कहते हैं all issues से finding केमती देवे.
अच्छा हो ठीक है. Let us accept it then.
Then my lords, it was the matter was remanded that what the trial court said, that it disturbed the finding of position. In the trial court at the first intent, they say the defendants were in possession of the land because the decree of recovery position was passed. But after remand, the trial comes to a finding that the defendants are not in possession. So, and this, against that, when the second time we went in appeal, one sentence, my lords, that issue, whether it is an open remand or a limited remand, then the appellate court one line and decide kar dele. You will also may come to the appellate court judgment.
Yes, at page.
Sorry.
Internal page तक कौन?
Rajesh Das.
The internal page अच्छी तरह.
Internal page.
Internal page or paragraph चाहे.
Internal page 6, paragraph 9.
Yes.
Upon the all the judgment of the first appellate court passed on dated 15/11/2014 does not disclose it as an open remand, but the entire analysis of the judgment reveals it so. According to the learned lower court framed an additional issue. This is the answer. This is the finding on memorandum of appeal. It is not an open remand, it is a closed remand. This is the finding, one sentence finding, non-speaking.
Then again, we'll have to go back to the order of Mr. Datta. The last,
yes,
you see, to the Rancoon, setting aside the improved judgment and remanding the suit bearing it to the learned court. So, if it is read plainly, it would mean that because it says that for adjudication of the dispute between the parties afresh by framing issues on the afore discussed aspects, whatever he has discussed, relating to the alleged Benami transaction and giving opportunity to both the parties to adduce evidence on that aspect only. So, evidence would be adduced only on that aspect, not in others. But all the other issues will be taken up on the basis of evidence already on record. That is what plainly means. Well, sir, this is my prima facie view, not the final view. Dissect kori very clear. Evidence you are permitted to adduce only on this aspect.
It is a fit case to remand back to the lower court for fresh adjudication by framing an issue on the Benami transaction as discussed above and giving opportunities to the parties to adduce evidence on that score and nothing more.
See, nothing more to likha hai nahi.
Again, likha. I got certificate copy also.
Very,
The culture.
very strange.
Nothing more likha.
The alleged Benami transaction and giving opportunities to both the parties to adduce evidence on that aspect only likha hai. तो पछार के वो करेक्शन करती है जजमेंट रे नहीं
वो सर्टिफिकेट कॉपी टा देखि दो
ये सर्टिफिकेट कॉपी टा ठीक हो सर्टिफिकेट कॉपी टा ठीक हो इसको ठीक हो
पेज से करते पेज में सर्टिफिकेट कॉपी सर्टिफिकेट कॉपी टा ठीक है पेज 17 में
giving opportunity to both the parties to adduce evidence on that aspect only. Out to to
the parties to adduce on that score and nothing more.
No, upon certificate copy certificate copy matches with the order that I have, with the judgment that I have in my system.
It is also a certificate copy.
It is 15/11/2014.
15/11/30. RFA 22 of 2013.
This is RFA 22 of 2013.
Mr. Dattan.
Yes, you see, you compare. Mr. Kunte, I would rather suggest that let us not argue it today. You go through all these. These are very, because your case rests on this.
Nothing more Ocherian. To the parties to evidence on that score and nothing more. Hence it is order.
Could लिखा है
लिखा है
Order just order ऊपर.
Oh, you are अपन मतलब कहले order टा देखिए पे ordering person. अपन जो body of judgment पढ़िए. ठीक है चलो तो तला दरकार नहीं. So evidence, so far as adducing of evidence is concerned, that will be confined only to this issue. But that doesn't mean that all the issues will not be considered, because he has positively said that all the issues will be considered. So far as, because he finds, consciously he finds that evidence is not required on other issues. That is adequate. Insofar as this issue is concerned, since a new issue will be framed and the Benami question will be decided, he has permitted the parties to adduce evidence. And he has made that on such, on that score and nothing more, only to prevent you from adducing evidence on other issues. That is the interpretation. Anyway, what is the other point?
Whether the findings of this reason, properties of the plaintiff to the learned trial court is alien to the pleadings and is.
So where is the question of Stridhan? Apan kujun pa sera property ta purchase heitala.
The trial court and the first appellate court come out a new case Stridhan.
Okay.
It is not neither the case of the parties.
They actually probably they meant absolute ownership.
Section
Probably. Section 14 तक से mean करिए वो लेकर Stridhan लिख
pleading
दीजिए.
parties for pleading रे नहीं. In the third case made out. That is why substantial.
No, that is a point we can take up. That is a point we can consider.
Whether the claim of benefit as advance by defendant are satisfied
Balaram,
all
who we call
prescribed ingredients. A ingredient of the appellate court discussed करवाने. ताकत जो ingredient 74 Supreme Court अनुसार से ingredient पे discuss.
Ingredients of what?
Of Benami transaction.
Oh, Benami transaction.
Custody of the
Yes.
CV colony. And the a point I need a argument, my lord. Your lordsmith, if today your lordsmith give me 10 million minutes, I will not take more than that.
Today you can argue. Who is stopping you? You can argue.
On the next point, this is
Your first point is on open or closed remand. Open or limited remand.
Second is Sridhana.
According to you, it is not open remand, but
Limited remand. Second is Sridhana.
Stridhana, yes.
Third is
Stridhana, it is nobody's case. According to you, it is nobody's case.
no, neither party's case.
Yes.
Third is Benami transaction ingredients because the first appellate court said Benami operate of the ingredients because he has discussed that 74 Supreme Court ingredients. Mr. Datta in his judgment. I got the locksmith come to order dated 10/4/21. Oh, I'm sorry. 16/4/24. 21.
Yes.
The advocate of both parties are present and files the respective hajira. The learning counsel present at the time of hearing heard argument put up on 26/4/21 for judgment. Here it starts 3/5/21. It was COVID. It was COVID in-laws. It says the case record is put up today. Court was declared as containment zone till 30th April 21 as per collector order. Advocate for both sides are absent. No steps have been taken to COVID. PO is availing summation put up for judgment. So it says put up for judgment. Suddenly, my lords, judgment is pronounced. That is, your lordship sees 19/5/21. The judgment is ready and pronounced in the open court. The argument was heard on 16/4/21 and the judgment was posted to 26/4/21. But in the meantime, court was declared as a containment zone 34/21 as per order of the sub-collector Sundargarh. And further, why thereafter the summer vacation started and you availed vacation. Hence, there is a delay pronouncing judgment for 24 days according to instrument annual court. The appeal is allowed. My submission is that on a holiday, no judgment can be pronounced in open court. Because statute
19/5 was a holiday.
19/5 was a vacation.
Oh, summer vacation.
Summer vacation. I have taken that ground in my memorandum of appeal. That is why substantial question. My lord, your lordship has experience over district administration, judicial administration. Your lordship may come to GRCO civil.
No, that I remember. But this was a peculiar situation.
Yes.
He should have passed a previous order saying that this matter is being taken up during summer vacation, citing the provision in the GRCO. Because of this. And then he would have, which he has done, he has written to the High Court because of to explain the delay, but he should have passed a small order. I don't think this will vitiate the judgment.
It will vitiate because after Anil Rai case and law was expanded. Anil Rai case must delay in delivery of judgment. Justice must be seen to be done. Say here gale.
It containment zone thila na.
Containment zone thila. Ta mane notice nahi to the lawyers and the parties.
For argument mein rakh dile hi thanda. But for pronouncement of judgment.
Had argument put up for.
So pronouncement of judgment fine. Anyway, I am taking note of it.
Hard argument.
Come to GRCO. GRCO bolta hai. Again.
Aap kona mein note kar dego.
Note kar dego. My lords, before I submit this, I am assisting your lordship whether my client loses or wins.
Well, that's a different matter.
One thing is against me before I open. That is Civil Court Act. Civil Court Act 11(2) they are short of a reaching. Sector gote achi 11(4). That holiday judgment deliberated will not be initiated. That is against me. I am assisting your lordship.
No, that.
Case of sitting of courts. Subject to other provision of this rule, no suit, no case or appeal shall be heard on Sundays and holidays under section 11(1) of the Odisha Civil Court Act. Next, question 2B. In respect of vacation provided section 11(2) of the Odisha Civil Court Act, arrangement of disposal urgent matters arising during vacation shall be made in the following manner. What is urgent matters? Matters which could have been moved before the vacation commencement or matters which can wait till reopening of courts after vacation shall not be treated as an urgent matter. 124%. 124 time of delivery of judgment. Ordinarily, judgments in all civil suit and cases should be delivered soon after the hearing. But where it is not possible to do so either on account of length of case or other sufficient reasons, the delivery of judgment should not be postponed cyanide act. A definite date should be fixed no more than 2 weeks after conclusion of argumentation, which date judgment should be delivered. But in any case, judgment must be delivered within 30 days from the date of conclusion of argument. Ethi कहला, delivery of pending judgments when judicial proceeds on leave or transfer. I count that vacation is a leave. Judicial officers shall be, before making over charge either on transfer or while proceeding on leave, deliver all pending judgments and intimate the fact of clearance to the concerned district judge and in district judges to the High Court unless exempted by concerned district judge of the High Court as the case will be. Then your lordship may come to CPC. Order 41 Rule 30. Deliver of judgment by appellate court. Order 41 Rule 30. Rule 30 case. Judgment when and where pronounced. The appellate court, after hearing the parties or pleaders and referring to any part of the proceeding, either whether in appeal or in court from whose decree appeal is preferred, to which reference will be considered, shall pronounce judgment open court, either at once or some future time, of which notice shall be given to the parties or their pleaders. Ichi agya heji. Date ta fix heji, containment zone heji. So on a holiday, तापर देखो तो जजमेंट भी इम्पूर्ड जजमेंट का टिके देखो तो केमती डेट भी मटेरियल वेरिएशन है पेज सेकंड पेज ऑफ इम्पूर्ड जजमेंट
ये साइन तो करते हैं इनिशियल तो करते
हैं सेटी देखो तो पूरी है सेटा बोले पूरी नहीं बिकॉज़ ऑफ डेट फिक्स है ना पूरी है
ସେ 20 ପାଞ୍ଚ କରିଥିଲେ ତାକୁ ବୁଲେଇକି 19 ପାଞ୍ଚ କରିଛନ୍ତି ଆଉ ତା ସାଇନ୍ ବି କରିଛନ୍ତି ଆଉ
19/5/2021 ସିଗ୍ନେଚର
नहीं सिक्किम वेट राइट अब नेक्स्ट वीक की डॉक्यूमेंट हां 10 minutes टाइम
yes
on that day.
no time is unlimited
उनके एड्रेस कर भी आज के
नहीं ठीक है हर्ड एंड पार्ट लेटेस्ट मैटर केबे गोट करो कितना पाठ है
तीनटा पाठ है
या एक मिसेल ने या कुछ छाड़ छठा होता से ठीक था हर्ड एंड पार्ट लेटेस्ट मैटर इन द वीक कमेंसिंग 17 September
आइटम 52 इंडियन बुक सर्च करछि गोटे 1800 केते पाइले त पाउ नहीं पोस्टली तो है केस फॉर्म गोपाल
अरे कितना केस है
सर्किट बेंच ऑफ मैटर साइकोट सर्किट चला गोपाल को पोस्टो ते पाउ नहीं तो I could not. Actually, I have substantial question over it. Raise करछि.
Whether it will be treated as a holiday or not. Vacation is not. No, sir, सुनो तो vacation is not a holiday. Had it been a holiday, no civil matter could have been taken up. Civil matters can be taken up on urgency being shown, and the court has to pass a specific order saying that because of this urgency, I am taking up. Now, this is a case where there was a peculiar circumstance. The court itself had been declared as a containment zone. He could not have pronounced the judgment on the day because on that day it was declared a containment zone. So the day he joined, immediately thereafter he has delivered a judgment. Unless you can demonstrate to the court, taking into account these peculiar circumstances, that you have been seriously prejudiced by pronouncement of judgment without notice to you, then this court may consider interfering. Otherwise, this will be a mere defect of procedure. Anyway, let us see 52. Item 52. Yes, anybody?
Item 52 praying for Passover.
Tomorrow. Yes, Passover tomorrow. 53.
And for the respondent number 6, my lord.
Who's the appellant? You are for the appellant? The appellant is not the 2022 matter. Let us say yes.
I've been in there would a miscase also. It will come along with the miscase.
All right. Let this matter in the Cool. In the week commencing 17th September, along with IA number kete? Along with an interlocutory application said to have been filed by the appellant. Yes.
Substantial question of law also not been framed here.
Sin dekhiye.
Item 54, yes, item 54. I expect on adjournment. This is matter that last occasion your lordship has admitted the matter and on my request it has been fixed today. We pray for next week, any date your lordship.
Next week as period. All right, next week as period.
In order to continue.
In order to continue. Yes.
Item 55.
Next week in the weekly list or your lordship?
Weekly list. Yes, item 55.
I have the appellant. Interim order to continue. In
Yes. 55.
My lord, in item 55, my lord, I had appeared for the respondent, my lord. But in the meantime, my lord, he has taken back the brief along with the.
Oh, yes, you were making, somebody was making a mention in the morning. Yes.
So
we'll have to issue note.
So our names may be taken, my lord.
What is your good name, sir?
Amlan Mishra.
Sri Amlan Mishra, Learned Counsel, appears and submits that the brief has been taken away by the respondent. So office to verify if any other counsel has been engaged for the respondent in the meantime. Place this matter in the week commencing 23rd September. Yes.
Item 56.
56 जाए कहीं कला क्यों? अरे 50 टका लगता है इतने कहीं कला? ओह पाठा. Yes, item 56. All right, pass over. Till tomorrow. Yes, pass over, Tako.
So item number 7.
Steps of substitution, vice respondent number 1 not taken, requisites for issuance of appeal.
clarify कर दे
5 to 8 by both ways with correct address not received.
सेटा दरकार नहीं मतलब your lordship में kindly dispense with super notice on respondent number 3 and 5 is concerned.
3 and 5.
My lord.
3 and 5.
My lord. That is because they are the co-defendants, your lordship, and your lordship will see, my lord, the suit was dismissed and in appeal it has been allowed. So therefore, those two persons, your lordship may kindly dispense with so far as the notice is concerned.
Notice on opposite party number 3 and 5 is dispensed with for the time being at the risk of the appellant.
Then one more thing I would like to point out to your lordship, so far as respondent number 1 is concerned, you are the plaintiff in the court below. But the instruction I have received is that he has not left with any error. Now, my lord, when the restoration application was dealt with, if your lordship, the restoration application is on record, then your lordship will kindly peruse. I think restoration application टा record रे नहीं की कौन list रे देखो
नहीं
सेठी मु सबमिशन करतली जे एई रेस्पोंड नंबर 1 करो कोन सी एयर नाहंती तेनु नथले ये
what will be the effect? Because he was the plaintiff. He was the plaintiff.
He was the plaintiff.
Now the decree
से नहीं तेनु मु परस्यू कर परिबी खाली what will be the modality मु एटा लिस्ट रे थाउ it can be taken up for hearing. Friday ने हम भाबुची assist कर दी परी बोली ना वर्तमान कौन
it has been admitted.
Yes, the appeal has been admitted.
I don't think so.
And the transfer one के
it's all right.
it will be mallet.
Yeah, it has been admitted. Substantial question of law has been framed.
Mallet.
So who is the plaintiff? Respondent number 1.
1. And CA वर्तमान देखले वाली से जो हिसाब करी भी cognate agnate देखी हिसाब करी बोधे appellant आसुई कौन से टा आउट problem हो जो मुझे से टा को
So he has no legal errors.
No legal errors. And that is the instruction and that I stated.
So what will happen to the decree then? What is the
decree can be pursued? Like for example, I will just give your lordship one example. Like in same principle manner be applicable in matrimonial cases where the husband gets a decree of divorce, wife challenges it, husband passes away. The appeal is pursued, and in one case, my lord, I do not know whether it has been reported before marriage Chalpatra. The daughter was made a party just to pursue the litigation, and that appeal was allowed. And
no, because there's a question of alimony there and payment of some.
Divorce decree was set aside.
But here, what about the? No, it could be set aside if the order is wrong. It could be set aside.
Here only I will.
What is the decree?
The
I'm
decree,
just
title declaration.
Title declaration.
Yes.
Now, how will it be enforced? Supposing your appeal is dismissed. I am just asking you a question academically. I want to know.
In fact, I think he has transferred portion of it in the meanwhile before death.
Before his
So,
death.
yes. So those consequences, my lord, will go once this is, if it is allowed in my favor. I'll just give your lordship one example. In 35 proceedings, the restoration is done. We challenge it before the Honorable High Court. Recently, what has happened? Post facto the decision of restoration, he had disposed of the property, and mutation was done. My case was allowed in view of the recent amendment saying that if the possession has not been taken over, then the 35 will no more be there. The lordship knows that recent amendment of the Consolidation Act. So my writ petition was allowed. Consequently, all consequential actions were effaced. Namely, the consequential held it because once the action is held to be illegal, the other consequences will follow. So whether I have a case for consideration or not, that your lordship will decide. And firstly, your lordship will decide how the appeal is to proceed. That I have to also assist.
Yes. That is
one of
a
the important
peculiar
aspects.
problem. Anyway,
Pray it for next week instead of Friday because
नहीं,
want to call
Friday
you
को
back.
next week करिए. Next week
I'll
कब?
find out exactly if
All right. This matter in the week commencing 9th September.
these two persons may be dispensed.
That I have already discussed.
And one, my lord, in fact, if your lordship calls for that MJC also, but that may be called for. There I have
Well,
made a submission nowhere. Therefore, in the interest of adjudication,
This is a matter in the week commencing 9th September along with.
my lord, I'll furnish that MJC
All right.
number. With your lordship.
ठीक है.
Okay, that will be
Then?
MJC. So I know 13.
Item 13. SRF status quo notice issued on last one right living by received by joint living brother.
Counter ଦେଇଛନ୍ତି ଦି ଜଣ ଏଥିରେ notice କେଟା ଯୋଉ noting ଅଛି can be dispensed with list ରେ.
No, but respondent number 8 can be made sufficient.
ଆଜ୍ଞା.
Joint living brother. Such notice issued on respondent number 3 received by head clerk with office seal and issued on respondent number 5 received by receiving officer with office seal.
I'm just assisting you.
That how can it be? Such notice issued in appellant number 1, respondent number 6 and respondent number 7 returned undelivered with the report dead. So A1, R6 and R7 they are dead.
ମୁଁ ସେଟା କହି ଦଉଛି ଦରକାର ହବନି କେତେ appellant 1 ଦରକାର ନାହିଁ କାହିଁକି ନା ARs are on record 2 to 5.
So we'll say first pass that order.
Right.
It is submitted that the appellant number 1 who has died in the meantime need not be substituted as his LRs are already on record in the form of other appellants.
2 to 5.
Yes. What about 6 and R7?
6 and 7, my lord, I'll just clarify. 6 and 7 କାହିଁ ଦରକାର ହବନି I'm clarifying. ହଁ ମୁଁ କହି ଦଉଛି. Now your lordship will see the trial court judgment. Trial court judgment, your lordship.
Yes.
ସାଧୁଚରଣ ମହାପାତ୍ର ଜୟନ୍ତ ଦାସ ଫାଇଲ କରିଥିଲେ ସୁଟଟା.
Yes.
ମାନେ ସାଧୁଚରଣ ମହାପାତ୍ରଙ୍କ ଏଆର୍ ହଉଛନ୍ତି ଆପଲାଣ୍ଟ ମାନେ ଆପଲାଣ୍ଟ ନମ୍ବର 1 ବର୍ତ୍ତମାନ ଡିଲିଟ ହେଇଗଲେ ବାଇ ଭର୍ଚୁ ଅଫ ୟୋର ଲର୍ଡସିପ୍ସ ଅର୍ଡର ମାଇ ଲର୍ଡ. Then the others your lordship will see are the
school and the government functionaries.
ସେମାନଙ୍କ ଦରକାର ହବନି କାରଣ ସେମାନେ ରିପ୍ରେଜେଣ୍ଟ ହେବେ ସେମାନେ ଅଥରିଟିଜ ବାଇ ପର୍ସନ ନୁହେଁ ସବଷ୍ଟିଟ୍ୟୁସନ ଦରକାର ନାହିଁ. ତାପରେ 6-7 ଯୋଉ ରହିଲେ 6-7 पर दरकार हबनी. I'm just assisting that. 6-7 your lordship. They were made parties before the appellate court. They were made parties before the appellate court. 6-7. I'll just assist that your lord. I'm hearing a very case.
Yes.
ସେମାନେ ଜମିଟା କିଣିବେ ବୋଲି କହିଥିଲେ ସେମାନେ ପାର୍ଟି କିଛି ଦରକାର ନାହିଁ. ମୁଁ ଡିକ୍ଲାରେସନ ରାଇଟ୍ ଟାଇଟଲ ଇଣ୍ଟରେଷ୍ଟ ସୁଟଟା ଥିଲା was against this government and officials school. So taku dispense with substitution 2244 re
So they are respondent numbers
6 and 7. ସେମାନେ appellate court
6
ହିଁ
and 7.
ଆସିଥିଲେ।
It is submitted by respondent. It is submitted by Land Senior Counsel Sri Mishra that a notice on respondent number 6 and 7 should they be deleted or notice be?
2444 that is dispensing with substitution. I am very sorry. I always say that bring the book, but
No. They are alive. 6 and 7. Oh, 6 and 7 are dead. All right.
Dispensing with substitution.
That they need not be substituted as the appellant has no claim against them or their LRs. Yeah. Considering the submissions as above, substitution of deceased respondent number 6 and 7 is hereby dispensed with. Yes.
Injunction दरखास्त थला status को हेतला in presence of the party on contest they have filed a reply. What I was praying for subject to your lordship's kind consideration is that the appeal may be heard next week. Injunction टा यदि absolute करियो करिवे न से जाय injunction रहिबो
Say thou will hear it. Who's for the other side? State will be appearing for some of the.
And it was my.
I don't have a copy of this record.
No, there is a Sri Krishna Academy or something like that.
ସେମାନେ appear କରୁଛନ୍ତି ସେ ଓକିଲ ମତେ ଦେଖା କରିଥିଲେ 2-3 ଦିନ ତଳେ।
Yes.
State ଅଛି
State is the party na?
ସ୍କୁଲ ଅଛନ୍ତି DPI ଅଛନ୍ତି ଗୋଟେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଫ ଓଡ଼ିଶା ଅଛନ୍ତି ମୁଁ ଦେଇଦେବି ଗୋଟେ କପି ସେଠୁ ତ ନୋଟିସ ଯାଇଥିବ ନିଶ୍ଚୟ ତଥାପି ମୁଁ ଆଉ ଗୋଟେ କପି ଦେଇଦେବି କାରଣ ଏଇ ଯୋଉ ତାଙ୍କର ବି ଚେଞ୍ଜ ଅଫ ଇଏ ହେଇଗଲେ ତାଙ୍କର
Respondent number notice on respondent number 8 is treated as sufficient. Yes. So only also nothing remains.
Nothing more remains so far as
Only so far as the state respondents are concerned.
ତାଙ୍କୁ ନୋଟିସ ଦିଆହେଇଛି ମୁଁ ଗୋଟେ କପିଟେ ଦେଇଦେବି
Let a copy of the appeal memo be served upon Land State Council who shall represent, who undertakes to represent the opposite party numbers 3, 4 and 5.
3, 4 and 5 years.
Yes.
Respondent.
Respondent 3, 4.
Respondent.
Yes. So that's all. List this matter for hearing. Week hoboni.
17 week रे रहू
17 week रे भी hobo.
17 week
In the week commencing 17th September. Yes.
से status को
Status को interim order to continue.
I prefer urgent copy.
Urgent copy. Yes.
So item number 19.
Madam MJC number I am furnishing.
Yes, please.
Put a sleep ready.
Yes. Give it to the court master.
Madam.
Item 19.
Madam, just sleep ready.
Yes, item 19, Mr. Bemukesh Sahu, he was here. All right, pass over. Then?
Password item number 22.
22.
Yes, well,
Condonation of delay.
the condemnation day, there is 14 days of delay in filing.
The notice will go upon. I issue notice to the respondents by registered post with AD making it returnable within 4 weeks. The requisites be filed within 3 working days. List this matter.
And we come to 28th October.
In the week commencing 28th October.
So item number 27.
Here, your appeal was filed in time. And kindly come to my limitation petition IU 819 of 2022.
Let me just see the SR. SR कौन है? Date of
IU 819 of 2022.
Is it 22 days question?
22 days. 22 days. Kindly see para 3 of my limitation.
RS on 22/4/2024. There is
Was filed within time and has been granted a diary number for the due to non-filing of certificate of trial court judgment within 1 month from the date of SR. The appeal has been dismissed, so I filed again the appeal, thereby 22 days delay. It is due to my mistake.
But then notice has to go.
Notice has to go. Now what happened? In the meantime, the delivery possession execution case has been.
That we will see. That we will see. Deleta condonation केमती state करते हैं?
Sir, it is not sir possession नहीं.
अपन कौन आती?
Sir, मुझे IE फाइल कर. ताज़ में नोटिस आ जाओ.
Notice টা ଯିବ
IA 103.
Take notice by special messenger if you are so worried about the property. Take notice by special messenger.
Sir, IA ଟା ବି notice ନେବେ।
ସେ ଆଇଏ କଥା କହୁଛି
Stay of-
Condonation of delay urgency କଣ? It is for the stay that you want, and since there is a limitation, I may not be able to.
ନା limitation ଭୁଲ ମୁଁ ନିଜେ କହିଛି।
ଯାହା ବି ହଉ limitation ଟା ଅଛି ନା,
ହଁ,
appeal becomes delayed.
limitation plus IA ଟା।
ଆଇଏ ଟା କଣ ଆଜି ଏଇଟା ଫାଇଲ
ନା
କରୁଛନ୍ତି?
ନା ପରେ ଫାଇଲ କରିନି ଏଟା ଆସିନି ରେକର୍ଡ ମୁଁ।
ତାହେଲେ ଏଟା ଆପଣ ରେକର୍ଡ କୁ ନେଇ ଆସିବେ ତାକୁ। ଆଇଏ 103 ଆଚ୍ଛା ଆଗ ଆଇଏ 819 of 2024 issue notice to the respondents.
Respondent କେବଳ 1 to 4 they are principal।
ହେଲା ଦିଟାକୁ ମିଶେଇ କରନ୍ତୁ, ଦିଟାକୁ ମିଶେଇ ଦିଅନ୍ତୁ। issue notice to the respondents by special
1 to 4. Yes, no, 1 to 4.
respondents 1 to 4 for the time being by special messenger, cost of which shall be assessed and deposit be made by tomorrow.
Right, right.
Special messenger ଆଉ ଗୋଟେ ଦିନରେ ଆପଣ ଦେବେନି?
କାଲି ଗୁରୁବାର।
ନା ଗୁରୁବାରରେ ଦିଆଯିବ, ସେ ହବନି, ବଦଳି ଗଲାଣି ସବୁ। ନା ଗୁରୁବାର ସେ ଆକ୍ସେପ୍ଟ କରନ୍ତି କି ଫିସ୍, ମୁଁ ସେଟା ପଚାର by tomorrow. A short returnable date be fixed. Is this matter on 30 next week କରିଦେବେ କଣ? କୋଉଠିକି ଯିବ? ଯାଜପୁର କେତେବେଳେ? Is this matter the supplement list on 13th on 13th September. Yes. ଫାଇଲ କରିଛନ୍ତି ସେ paper list ତାହେଲେ ତାକୁ ନେଇ ଆସିବେ। Yes.
Item number 28.
May pleasure, Lordship. In this case, there was a delay about 20 days, which has already been condoned by the order 30th of April 2024.
Yes.
Now, my lord wanted to know what are the substantial question of law. In this case, the substantial question of law I have mentioned in page 6, my lord, of my appeal memo.
No, what is the matter? You tell me. Otherwise,
regarding declaration of a right title interest. I
Who
am
are you?
Present appellant. Present appellant was a defendant and appellant in court below, my lord. And the
this is against a reversing judgment.
Reversing judgment.
What was the suit for?
A suit for a declaration that the purchased property belongs to the present respondent. But that purchased property was not properly purchased because it was an invalid sale deed, my lord.
Why invalid?
Because, my lord, the wife has sold in the year 1942 when the property right to the woman has not come. And moreover, by that time, his son was 28 years of old, my lord. That point has not been taken into consideration. And so far as issues are concerned, my lord, on these aspects, I filed my WS, but no issue has been framed. And your lordship may turn to lower court judgment.
So the suit was dismissed?
Suit was dismissed. And
Okay.
against that, no suit was allowed. Against that, I preferred appeal. Appeal was also confirmed.
So it's a confirming judgment?
Confirming judgment, yes, madam. But all these points has not been taken into consideration. So far as substantial question of law is concerned, this is a residential house, joint family residential house. It has not been partitioned also. That is a finding of both the courts. But that point has not taken into consideration. So far as the substantial question of law 1 is concerned, whether the learned court below has justified in declaring the suit of the plaintiff in view of the evidence laid down by the defendants that the properties in question are joint family undivided homestead land. So it cannot be homestead land, cannot be alienated, my lord. One question. Second, my lord, whether the learned court below has justified in applying the provision of section 90 of the Evidence Act when the appellant has challenged the same that those documents have been executed in respect of undivided joint family property, my lord. That point has not been taken and no issue has been framed on all these issues, my lord. And so far as substantial question of number 3, my lord, whether the learned court below has justified in not entertaining the plea of the appellant with regards to applicability of section 44 of the TP Act and section 4 of the Partition Act. The property was not partitioned. All are living jointly, my lord. Out of that, one co-sharer cannot sell. First of all, preference should be given to the other co-sharers. That point has not been read, my lord. And so far as the fourth,
there is nothing about the sale in the validity of the sale deed which you have just referred to.
Yes, no, that has not been taken into.
No, you have also not substantial question of law. Also, you do not say anything about the sale.
Still, my lord, yes,
No,
that
our
is
point is-
there. Whether the land court bill has justified in saying that the separate possession of the, it 6 days, my lord. 4 days, whether the landed court below are justified in decreeing the suit, ignoring the settled position of law, that mere possession of the joint family land separately without being partitioned by metes and bounds will be construed as a partition and basing on the view whether the sale deeds are valid in the eye of law. এই ଯୋଉ ସେଲ୍ ଡିଡ୍ ଦିଟା ସେ କହୁଛନ୍ତି ଯେ ଆମେ ସେଲ୍ ଡିଡ୍ ରେ କିଣିଛୁ ସେଥିରେ ସବୁ ସେୟାର ହୋଲ୍ଡର୍ସ ସାଇନ୍ କରିନାହାନ୍ତି. One of the mother has signed at the age of in the year 1944 when the right to property act was not there, my lord. And by that time also son is there whose age is more than 28 years, my lord. All these aspects has not been considered by both the courts below. And if I will request your lordship the issue, my lord. Issue, none of the points has been taken in the issue, my lord.
All right, I'll admit it on 2, 3, and 4.
Yes, ma'am.
One is not.
One is not so important, my lord.
Yes. Lord Sri Vidyadhar Pradhan, legal counsel for the appellant. Peruse the impugned judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial questions of law.
Madam.
Page 60, 2, 3, and 4. Sitting. Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. LCRB called for, close this matter.
28th October.
28th? Yes.
My lord, in this case, there is a defect that a consolidated cost title incorporating a respondent 1B not filed. I have filed and I have a sort of copy also to the learned friend who appeared earlier. My lord. There is a noting in the list, my lord.
Consolidated cost title.
Yes.
I got a consolidated cost title is filed in the court today. Yes.
Appellant number 1B, my lord.
Consolidated.
So item number 29.
May I pray for a week time? My file was misplaced. I have reconstituted the file. Week time, your lordship may fix it to week commencing 17th.
May I please your lordship? Item number 29. I am from opposite party.
This has come for admission, so.
Madam, am I audible to your lordship?
This is a 2014 matter, Mr. Das.
My
This
lord,
has not yet been admitted.
I will get ready in the week time. 1 week time.
Or at least this, as requested by learned counsel for the appellant, let's this matter in the week commencing 17th September.
It's an interim arrangement, interim order.
There is an interim order. There's already an interim order.
But interim order with regard to no further construction either both the parties.
No, is there an interim order?
My lord,
When was that order passed?
that order was passed on 26/3/21,
All
my
right,
lord.
all right, all right. Interim order dated 26/3/2021 shall continue till the next date. Yes.
Okay.
So item number 33.
Appeal against confirming judgment. The appellants herein were the plaintiffs in the trial court and the appellants in the first appellate court. The suit was one for declaration of right title and interest over the suit land and recovery of possession. The pleadings of the plaintiff appellants are that the suit land was recorded in the name of the common ancestor of the plaintiff. That is the father of the plaintiff's numbers 2 to 7 and the grandfather of the father-in-law of the plaintiff number 1 and grandfather of the plaintiff number 2 and 3. And the further pleading is that the suit land in the Sabik settlement was recorded in the name of the common ancestor of the plaintiffs, that Niranjan Panda, in the Sabik settlement. And it is stated that it was the self-acquired property of their common ancestor Niranjan Panda, who was working as a ranger in the forest department, and later on he resigned from the job and started his profession in business by starting a sawmill, and he had sufficient means to acquire the land. He had acquired the shoot land, constructed a house thereon, and permitted his younger brother, that is the original defendant number 1, to reside in that house. And later on, during Hall settlement, the plaintiffs remain outside of the place where the shoot land is situated. They came to the place and met the settlement authorities. It is stated that the settlement authorities assured them that the shoot land will be recorded in their name, but subsequently they found that in the Yadast, the name of the defendant number 1 and 2 were also incorporated. That is why they met the defendants.
So there was a joint recording.
A joint recorded. Both the plaintiffs as well as the defendants number 1 and 2. So it is pleaded that thereafter they met the defendants, requested them to vacate the shoot land, to which the defendants filed a civil suit. And the civil suit was later on dismissed for default. And thereafter, after the dismissal of the civil suit, the plaintiffs again met the defendants, requested them to vacate the land, and it is stated that the defendant number 1 sought 1 year time to vacate the shoot land.
That dismissal of the suit
After the dismissal of the suit.
that was never restored.
No, the suit was never restored.
All right.
That order attained finality. And thereafter, as they did not vacate the suit land after 1 year again, the plaintiffs filed the present suit. And the defendant number 2, defendant number 1 did not file any written statement. Defendant number 2 filed a written statement with a counterclaim. But the defects were not removed and the WS was not accepted by the learned trial court. And thereafter, evidence was adduced, issues were framed. How issues were framed? It is because the WS was not accepted. And both the parties have adduced the evidence. And the findings of the learned trial court, as well as the first appellate court, are same as regards the reasons for dismissal of the suit. The number 1 ground that is taken by both the courts below is that the suit land is not identifiable properly and is accordingly liable to be dismissed under Order 7, Rule 3 of the CPC. What has happened in the suit land? The Savik Khata number and plot number is being mentioned, and it is a whole plot, not a part plot. And when it can be identified by a particular plot, then no further description is needed as regards the suit land. And the reasoning for resorting to this rule is that the corresponding khata number and plot number of the Hall settlement has not been mentioned. What has happened? The Hall settlement records had not been published by the time this suit was filed. And accordingly, the Hall number could not have been incorporated in the plan. However, after this finding was given by the learned trial court, the plaintiffs filed an application for additional evidence by filing the corresponding Hall Savik plot can be obtained from the settlement authority by asking the information.
The plot index.
Your Lordship. And accordingly, they filed an application for adducing additional evidence by furnishing that document. And that too was rejected on the ground that will patch up their case. That is a technical defect, and the technical defect, if any, should be removed. And that is why the suit was dismissed. That is ground number 1. Ground number 2, it is stated by both the courts below that the plaintiffs have not proved the basis of their title. As I stated earlier, my lord, the suit land was recorded in the name of the father of the plaintiffs, the common ancestor of the plaintiffs, in the Savik settlement of the year 1955-56, and that continued till the Hall settlement. So, as per the well-established principle of law, the burden of proof shifts on the other side who seeks claim. And moreover, the claim of the dependents having been lost in the civil suit, they could not make any further claim. And thirdly, it is stated if the learned trial court has allowed them to adduce evidence in spite of the fact that the WS was rejected.
All right, we'll admit it. How is H.K. Moore, learned counsel for the appellants? Appellants. Appellants. Peruse the impugned judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial questions of law. Page 14, 1, 2, 3, 3 times कर दें. Issue notice. The respondents by registered post with AD returnable within 4 weeks. The requisites be filed within 3 working days. Call for the LCR. Close this matter in the week commencing 25th November. Item 51 रे interim order to 51. Yes. अब कितना थे लेंगे admission रे? Admission रे? दीदा का पास होता है. निकाल देखिए.
Item 37 I pray for an adjournment.
Item 37. 2005. No. Let it come tomorrow. We'll see. 2005 matter very difficult.
Yes. Tomorrow I may seek 1 day accommodation for Friday. 2 matters are there, passed over. If not tomorrow, can it be on Friday? My friend will be there.
Friday को बहुत order रह गए तो hearing matters. Kind ये I am done with I am already covered the list. Again I am going on the passover mode. So tomorrow देखिए all right.
I was there where I am the respondent. They have not served me a copy. Monday it was there. It was passed over. So if it is
All right. Ask your associate to make comments.